Ladies and gentlemen, we're going to call to order our continued hearing this evening. This is on the application of the Society for Preservation of New England Antiquities, doing business as Historic New England. We had our original hearing on this application on April 16, 2015, and we continued the public hearing to this evening so as to allow the attorneys for both parties to confer with themselves and the neighbors and hopefully come up with certain conditions that they mutually agree upon, and to tell us which conditions or modifications of conditions they are presently in disagreement on. So in that interim period of time, we did receive a letter from the applicant, from Attorney Alan Lipkind, dated May 12, 2015, with an array of plans and materials attached to it, his suggested modification of proposed conditions, and setting forth the conditions that the, I'll call it the Eustace estate for simple purposes, agrees to. We also received a letter dated May 12, 2015, from Attorney Dan Hill, representing certain of the neighbors, setting forth his position on the proposed conditions. So we thank both Attorney Lipkind and Attorney Hill for their contributions to the process. Let me just cover a few preliminaries and we'll start to get into, yes, I have that, I don't need it. My name is John Leonard. I'm chairman of the Board of Appeals. With me tonight to my immediate right is board member Jeffrey Mullen. To my immediate left is board member Stephen Lundbohm. The rules of this hearing are going to be the same as the first. We'll hear from the applicant in any further presentation that they want to make. We'll hear from Mr. Hill on behalf of certain of the neighbors. We'll hear from any member of the public who wants to speak. We're tape recording the proceedings this evening, so would ask that anyone, before they speak, tell us your name and address. Speak up nice and clear and loud. This is a fairly large conference room. The acoustics are not the best, so that we'll know who's speaking, and if we have to revert to our notes or the tape recording of the proceedings, we'll be able to reflect accurately who is making various positions. We did receive in the interim, in addition to the packets from both lawyers with respect to proposed conditions, we did receive a letter from Attorney Robert J. Sheffield of Milton, Massachusetts. Mr. Sheffield is trial counsel here for the Eustace estate, and Mr. Sheffield asks that any decision of the Board of Appeals be rendered in the name of the legal name of the applicant, the Society for Preservation of New England Antiquities, DBA Historic New England, so that the record title of the property will be intact. I'm going to construe this letter as a motion to amend the application to formally change the name of the applicant. And I'm not going to read Mr. Sheffield's letter. I think it's brief and to the point. Let me ask my colleagues, do any of you want to be heard on Mr. Sheffield's motion to amend and change the name of the application? Mr. Mullen?
No, thank you.
Mr. Lundbohm?
No, Mr. Chairman.
Mr. Hill, do you want to be heard on this application? Does anybody want to be heard on Mr. Sheffield's motion to amend the application, just to change the formal legal name of the applicant? Since nobody, is there any discussion? All those in favor of granting Mr. Sheffield's motion, say aye.
Yes, aye.
So we'll allow your motion to amend, Mr. Sheffield, and thank you for your letter. I think that's the appropriate way to handle this particular matter. Let me ask the applicant, Mr. Sheffield, do you want to be heard on where we are in this process? And we're delighted to hear anything else you want to say. What we'd like to do tonight is we'd like to bring this proceeding to an end, but we certainly want to make sure that everyone has the full opportunity to be heard. So welcome back to the Board of Appeals, Mr. Sheffield.
Thank you, Mr. Chairman.
You want to come up here and have a seat or make yourself comfortable?
I would like to introduce my co-counsel, Alan Lipkin, of Burns and Levinson.
Sure. Welcome to the Board of Appeals, Mr. Lipkin. Good to meet you. Were you here at the last hearing?
No, it was not.
Okay, great. Well, then, welcome to the board. Grab a seat and make yourself comfortable. We're delighted to see you. Whomever wants to speak first is fine with me.
Yes, good evening. I'm Alan Lipkin from Burns and Levinson on behalf of Historic New England. With me today, in addition to Attorney Shetfield, is Diane Vieira, who was at the last hearing, and Ben Harvick was here. He's on the facilities team at Historic New England. I'd just like to briefly tell you a little bit about the project and then really get right into the conditions where Mr. Hill and I, we worked to try to come to an agreement. We did on some, we didn't on others. So I'm going to try to focus most of my remarks on the ones we didn't agree to, if that's acceptable.
That's perfect.
If at any time you have any questions, obviously, fire away and I'll do my best.
We're not bashful, Mr. Lipkin, and particularly my colleague, Mr. Mullen.
I got that from watching the last tape, so I'm ready.
How did we look on tape? As terrible as we think we did?
Didn't do you justice, much better in person, but the tape was good. I've worked with Historic New England for a long time. They're the oldest, largest, most comprehensive regional heritage organization in the country. As you heard last time, they have 36 historic homes that they operate as house museums. What you didn't hear about last time is they also have stewardship programs, which is where most of my work has been with them. In other words, someone has a historic house, they want to put a preservation easement on it, they give a preservation easement to Historic New England, and the perpetuity Historic New England will make sure that historic house is held to be, historically appropriate, and they go to battle over that when need be. But we're here today about a house museum. It's Historic New England's goal to bring history to life while preserving the past for everyone interested in exploring the authentic New England experience from the 17th century through today. It didn't get to be the oldest and largest of what it does here by abusing its neighbors or renting out its historic structures for frat parties. The members of our organization are your neighbors, our board members are your neighbors. They understand the concerns and the fears of the neighbors when there is change, but they're sensitive to that, and the last thing that they are going to do is something that imperils their property, or more importantly, imperils their good name. They have an interest in keeping good relations with the neighbors. I read Mr. Hill's letter. As I said, I work very well with Mr. Hill. We disagree amicably, but to make reference to the size of the endowment that Historic New England has, I think is completely irrelevant to the decisions before this board, which I think is to take into account the uses, and I'm going to address those, see if they have an impact on the neighbors, and if they have an impact that's appropriate to deal with through zoning, put in an appropriate condition. If Historic New England and this structure that's in the middle of an 80-acre site has an indoor function or an Easter egg hunt in the spring, those events, in our view, will have absolutely no impact on neighbors, which it's board order condition, whether the endowment is $100 million spread amongst 36 houses, $10 million, $5 million, or a nickel. The focus of the board ought to be on the impact of the anticipated uses on the neighbors. And to some extent, at the last hearing, I watched it on tape. Historic New England started out on its heels a bit because, as Historic New England usually does, before it even got to this board, it met with the neighbors. Mr. Sheffield met with a different attorney who was representing the neighbors back then, and we thought we were close to an agreement or a decent set of conditions that wouldn't need much of the board to resolve issues. I attached to my package not only the assessor's map to give you an idea of where all the parties are and the distances between the parcels, but if you look at tab B to my letter, you'll see that's a plan that this was our initial plan for the property. You see Chestnuts Run going up kind of the left side of the picture, the museum's in the middle, and our parking area was in an area that's I think it's an orchard that was planted in the 70s. The traffic was going to go up to the right of the gatehouse, then cut left to avoid, you'll see a grouping of trees there, and that grouping of trees is very important, as you'll hear a little bit later in my remarks. That's a grove of very old sugar maples and hemlocks, and we took the traffic up that way because we were taking it off of the lower part of Chestnuts Run. This is the museum traffic. And you take a left there and then a right on Chestnuts Run. And that part of Chestnuts Run, Historic New England owns on both sides of the road. Chestnuts Run goes right through our property. And we were going to put the parking up there in the in what I would call the orchard area. We met with the neighbors. I didn't, but other people did. Mr. Sheffield met with another local attorney. Apparently, they didn't want to see the cars or see the people associated with the cars for whatever reason. We came back to them with this plan that's at tab C, and it's largely the same as the plan that you have in your package, the package of plans. I think it's, if you look at the one that's called site plan. And a lot of work, it may not be apparent to you, went into this site plan to move that parking area over. Now we're cutting a plan through those sugar maples, and trees may not, I don't know what all your feelings are about trees, but the landscape that's associated with this historic structure and the way it was set up by the Eustace family is very important. I stood in the middle of that grove of trees before I came over here, and there are some very, to my eye, I'm no arborist, but there's big, thick sugar maples, and they picked a path through those trees to maintain the outline of the grove, so the change would be as imperceptible as possible, and they're going to have to pick a path through the trees.
You know the width of that path, Mr. Lipkind? Approximately.
I have it in my papers. I don't have it at my fingertips. I can give it to you at the close of the hearing. And you may recall, if you look at the site plan C1.0 that we gave to you, we moved the parking area over. If you look on tab C to my letter, we're putting in a thick vegetative screen at the edge of the parking area. And I don't know if you do have the proposed site plan with you, but I took out another copy just for ease of reference, if I could give it to you, and I highlighted just 3 features on it. So please give one to Mr. Hill.
Do you know how high the plantings are on the edge of the parking lot there?
You mean the ones we're proposing?
Yes, you're proposing to build.
I could look at the landscape plan, it might be on there.
Mr. Hill, do you have a copy of this?
I do. 32 to 44 inches. They're being spec'd at 32 to 44 inches to start. Height, yeah.
The height to start is 24 to 36 inches. I assume with time they'll grow, but it's all shown on the planting plan at the back of the package. The reason I've given you the highlighted proposed site plan, I think Mr. Hill got a copy. You can see on here that proposed crushed stone drive, and that's the one that's going through the grove that I just mentioned to you. You can see the proposed parking spaces that are there. We got 48 in the crushed stone, and then the overflow, 56 parking spaces. That overflow 56 parking spaces butts right up against a wetland buffer, and I guess the point of this exercise is to show you that it took a lot of work to engineer that.
I'm sorry, can you hold on one second? Hey, gentlemen, could you keep it down? We have a hearing going, and we can't hear a thing with all the chat. Mr. Levin.
Thank you. We did that work to take the parking and the traffic completely off of Chestnut Run, even though Chestnut Run goes through our property and HNE owns the land. If you look at the if you look at the assessor's plan that I gave you, at least another 300 or 400 feet on the other side of Chestnut Run. And that took a lot of work to do it. And the reason I'm bringing it up is really to address a request that Mr. Hill had in his conditions, that he had a very broad request. I don't remember what the exact words are, anything having to do with this be moved 200 feet off Chestnut's Run. We moved that parking area as far as we could, and it's not just a matter of shift things a little bit more. You're going to be running us into
Into the wetlands.
and it's not that easy to fit parking spaces in. This may look from the top down on an aerial view like A and B, like everything's flat and you could just move things around, but the property slopes in a lot of places and we're running up against that wetlands. And I just think that if you go out there, it's tough to even see other houses, at least in the summer when the leaves are out. So like I said, we own the land on both sides of that Chestnut's Run. I think I'm going to move into intensity of use because my memory of watching the last hearing on the tape was that's something you wanted to hear about.
Yes, sir. Could I just ask you one question? On Chestnut's Run, on your Exhibit A that's attached to your letter, you have that indicated in red, do you not?
I thought it was pink, but we'll go with red.
It is pink. You're right, it is pink. And I know you didn't draw this to scale.
This is an assessor's map, and I just took a highlighter and went over it.
Okay. Does it attempt to indicate the rough position of the road, and then you indicate additional land that I'll call it the Eustis Estate owns on the other side of Chestnut Run as well?
Yes.
Which is what you were referring to
Yeah.
when you were talking about Mr. Hill's proposed condition.
Right. In other words, if you're looking at the map, Chestnut's Run is highlighted in pink, and I think he wants a 200-foot area where nothing can happen, starting to the left of it,
Yes.
Okay?
But you actually own large acreage to the left of that.
The left and the right.
And
We
the
own
right.
on both sides, going up to the Jeffries lots. I mean, I got that information off the assessor's website, who owns what lot, and I tried to get the people that I thought Mr. Hill was representing.
Great, thank you.
Except I don't think he represents Paiz. I'm not sure how to pronounce that, P-A-I-Z, but I figured they were on the road, so I included them.
Great. Why don't you talk about intensity of use?
Thank you. Yes, I think that the last time we were here, Ms. Vieira went into that to some extent, and you questioned her about that, and she gave you a handout. I incorporated a lot of that into my letter. But I think what I'd like to address is there's this concept of a numerical limit on the number of, we both use the phrase special events in our proposed conditions, but we define those differently.
Yes.
And you have to bear in mind when you're talking about special events, I mentioned that one of the missions of Historic New England is to open these historical facilities to the public. And this doesn't mean little old ladies or little old men inside the house looking at the fabric on the wallpaper and seeing, gee, that's the way it was back in, whenever this building was built. It means opening up the outside of the property as well, seeing the setting of the building, the landscaping to the public, and that would include kite fairs, other sites that Historic New England has, occasionally brings in an old-time baseball game, Easter egg hunt, things like that. If you look in our letter and Ms. Vieira's handout from the last time, it gives you some of that information of the types of events that we have. If you look at the condition as drafted by the neighbors for events that would be subject to this numerical limit, it's a very broad definition that I think is asking the impossible of your building inspector. An event, here's the definition, an event that is not directly related to the principal use of the property as an architectural museum. Maybe the members of the board could figure that out on the fly, or the Supreme Judicial Court, but I think that's just an invitation to dispute. I think the definition ought to take into account what is going to impact the neighbors. And I don't think indoor events in any way will impact the neighbors, other than they might see people if they walk onto HNE's property up to Chestnuts Hill Run, and take a look over, they might see people. Our parking's going to be behind bushes. It's HNE's position that indoor events ought not be subject to this numerical limitation, nor should outdoor events without sound amplification. Because if that's not the case, you could have an Easter egg hunt one day, then for a whole month you'd be barred from having an outdoor event with amplification. And I don't think that the neighbors, I understand people are concerned about noise. That seems like the principal concern of the neighbors. That's what I'd be concerned about if I was a neighbor. But I don't see how a ban or a numerical limit on indoor events impacts that, nor an outdoor event without sound amplification, especially where you take into account where this building is and where the neighbors are. I just don't see it. When in reading Mr. Hill's letter, it's very well written, but when you purchase a lot of land next to 80 acres of developable land, it's not reasonable to expect that you're never going to see or hear someone, especially when your access to your property is directly through the middle of someone else's property. We think, and would request the board to adopt the condition as we drafted it, that only outdoor rental functions with sound amplification ought to be limited in number, because truly those are the only ones that could have an unreasonable impact on the neighbors. As I said before, I went through the process of Mr. Sheffield meeting with the neighbors. We moved the parking area. We also made a very, very big concession on the number of events, bringing it to 12 per year at a maximum of 2 per month, bearing in mind the seasonal nature of outdoor events. Without speaking to the client, I would guess you probably have 4 months at the most to do outdoor events, like a wedding. You're taking a risk if you don't do one in July or August. It's a big concession. We made it, and to our knowledge, at least, I don't want to misstate what Mr. Sheffield told me, I don't think anyone else in town of similar use has that sort of numerical limit. If, and I understand the neighbors are concerned and you want to do justice by them, but they are not without remedies in addition to what the zoning board might impose. Like everyone else in town or anywhere else in Massachusetts, if a problem arises and there's too much noise, they can call the police or they can call HNE, or they could bring an action for nuisance and get an injunction. It's not an immediate gratification of having a condition in a zoning board decision, but if it's let's say in the off chance there's noise and sometimes things don't go according to plan, what is really going to happen if someone's noisy at midnight? Not that
Call
that
Mr. Sheffield.
They may call Mr. Sheffield. They're not. I don't think they're going to call one of you.
Pull
They're
the
going to
plug.
call. They're going to call the police, or they're going to bring a suit for an injunction. I just think it's your board. I don't know what conditions you usually impose. I sit on the zoning board in my town. We tried to avoid putting conditions in that are more appropriately handled by other regulatory regimes or private agreements between the parties. I just want to say a brief word about the fact that raising funds is essential to the core mission of historic New England. And yeah, if you look at, they have an endowment, yes they do, but if you keep spending your endowment, you end up with nothing. And let's say they make $5,000 on an event and lose it, that's a lot of money. Each of these properties they have to look at separately. When you're out there fundraising in the charity world, there's not really much, no such thing anymore as unrestricted funds. Everything's related to a purpose, and they're going to compare this property to others, and it's got to do as well as it can to running on its own. If I could, I'd like to move off of this idea of what events ought to be regulated in the number. As I said, we think it's only outdoor events with amplification, 12 a year, 2 per month. I'd like to speak about proposed limitation on the term. I watched the tape the last time. You did express a desire to have, I think you called it a look-back period. Something like, I don't remember who said it. I watched the tape a couple of times. And to us, I'm advised that there's a standard condition that the board adopts that says that things can be amended at any time in substance, not those words. And when you add that to the fact that someone can go get an injunction, we don't think there should be any term limit, or I wouldn't think so, but I drafted one, and I picked a 5-year term for a few reasons. I thought that there's precedent for it in your zoning bylaw. I think it's the wireless
Telecommunications.
Telecommunications
telecommunications
Act,
for
yes.
5 hours. I tried to use the methodology in that case I gave you where it's automatically renewing unless someone objects, and then there's a...
Pardon.
Right. I forgot the name. That's the methodology that I tried to go with. Having a 2-year period, especially running from the time the permit becomes final, this property is not going to open for another year. So when you get to a point, once we open, we'll have basically a 6-month period of operations, and we're going to have to tell people we can't book your functions anymore because we may lose our permit in 6 months. This is a property where the client, I think you heard last time, the client paid $7.2 million for the property. They're spending another $4 million on top of that to tie into the public water, to fix the failed septic, for accessibility repairs, new driveway. I showed you the plans for cutting the path through the trees. So I think that the 5-year period is much more appropriate if you're going to impact any period. As I said before, we're not going to operate at all for a year, and I don't think you're going to get a good picture on how in demand this property is going to be. I'm informed by Ms. Vieira that when they open these things up along the other 36 properties, there's kind of a novelty effect. People in the organization know we just got this property, let's have an affair there. After that, it kind of dies down, and the neighbors remain protected by nuisance law. And if I could, I'd like to move on to noise.
Fine.
Again, you weren't bashful last time. You already got the facts of the case, so I'm just trying to focus on the conditions
I appreciate
where
that.
Mr. Hill and I didn't see exactly eye to eye. Noise, I think, is a legitimate concern in theory, but if you go out there and take a look, or if you even look at the assessor's map, there are great distances out there. I'm informed, having gone out there, if you go out there, the back of the property, as you head back to the Shallingford lot, there is a farm operation back there run by Brookwood Farm. The farming equipment runs, I don't know how often, that seems to make noise. It doesn't seem to bother anybody. Mr. Hill suggested that this board adopt a DEP regulation. I think the DEP regulation, if it applies, it's there, and as stated in the regulation, it's to be applied by the Board of Health. It doesn't need to be part of a building permit decision.
Can also be enforced by the police department, fire department, or building inspector,
Right, that's all stated in the...
without it being in any decision.
And I think that's a more direct route than let's go dig out the special permit when someone's making noise when it's too late or it's too loud, things of that sort. So I think it's more appropriate, if you're going to adopt a noise standard, all I put in our proposed conditions, that the noise not be unreasonably loud, and that's, if they want to seek relief at the zoning board, I guess, maybe the zoning board, if it wants to entertain that sort of dispute, that's fine. Now, they also have a condition that directing amplified sound 180 degrees from Chestnut's Run. I don't think that the board ought to impose any condition directing which way speakers ought to be facing. I take it in looking at Exhibit A to our plan, to my letter, which is the assessor's map, 180 degrees be pointing towards, I think it's lot number 2. Can you make out lot number 2? It's kind of fuzzy, but it's towards the left of the page. That's where they would want the speakers pointed. We think, in taking into account where the trees are and the topography, that's not the way, that's not the way.
Go ahead, I'm sorry.
Yeah, we think a tent would be located just behind and to the left of the house, and the speakers would be facing towards Canton Avenue. And it's a little bit deceiving on this map, but I was out there today. It would really be pointing towards the gatehouse. That's the way the property and the trees and the tent would line up. It's a very far distance to anyone. It's not heading towards Butler. And again, as with the neighbors are protected by the noise regulation if it applies, and also by general nuisance law. And they're also protected by the decades, for what, I know it's not something you could take to the bank, but it's as close as you can. The decades of operating these things that Historic New England has run these things for. And if an issue ever occurs, they deal with it. That's how they got to be where they are. Now I'd like to address, if I could move on from noise, the proposed condition that says all outdoor activities and components of special events have to be 200 feet from Chestnut Run. I'm not sure what that means. I imagine it means that they want us to move our parking area even further. But you know, if we're having a wedding and the parents of the bride or groom want to take and walk in the orchard, I mean, we own the land for another football field on the other side of Chestnut Run. No one's even going to see them unless they're driving through our land, as they have the right to do. I think it's not reasonable. I think it's overkill. If we're having a kite fair and the kite flies over the apple orchard, is that, I'm not sure what it means. I think it ought to be eliminated. I think of it as a solution without a problem, and moving the parking areas, really, it's going to be very difficult to deal with that. With that, I think most of the other conditions, I think Mr. Hill and I agreed on. It really comes down to, I think, the noise and what's a special event and how many of them. So I don't want to take up your time unnecessarily. I know you're pretty busy, so if you have any questions, I'd be happy to answer them.
Great, thank you very much. Mr. Mullen, do you have any questions of Mr. Lipkin?
So when you say that the DEP noise ordinance, if it applies, can you expand on that sentence, what you meant by that?
Sure. I'm not a noise expert by any means. I do some permitting work. I've seen it applied in cases. I work with a concrete manufacturing company. They come out and they test the ambient noise. They test the equipment you want to put in there, and they measure the difference. Here, if you look at these regulations, it talks about if you look at the definition, in order for noise to be regulated, it has to have an unreasonable interference or impact on somebody in order for it to be considered noise pollution. That's how I read this stuff, and I don't know whether anything we'd be doing here would be subject to it. There's another provision in there that says that it does apply to public gatherings and things like that unless they're permitted. Now, I'm not that familiar with your liquor laws here in Milton, but I know there are some circumstances. Mr. Sheffield explained it to me. I've got to confess, it didn't all sink in. I was trying to get the rest of the picture. There are some circumstances where someone has to go get a permit from, I think, the Board of Selectmen if you want a liquor license.
Daily
One-day
permit.
permit.
One-day permit, yes.
Yeah,
That's
so-
my understanding as well.
I'm not sure if you get that permit, does this still apply? I don't know the answer to that, and I just didn't dig that deep, and I apologize for that. I'd be happy to look into it and give you a supplemental filing, but
I
it
don't
probably applies. I'm just not that sure about how the liquor permitting works here.
I would say that I've been to many Board of Appeals hearings in the summer nights when there's a band playing outside the town hall, and it surely it exceeds those standards. But you know, it's music, and most of the time, unless it keeps you from hearing what's going on, it sounds fun.
Mr. Mullen, do you have any further questions? Mr. Lundbaum?
Yes, I had a question. Looking at tab B, I think we see I think what purports to be the,
I'm sorry, I missed the last thing you said, sir.
on your tab B,
Yes,
I think we see what purports to be the event tent, that white.
yes.
Okay, I don't see it on C, but is it fair to say you did have to move the parking?
Yeah,
But it
that tent was originally supposed to be, I believe, on a pad, and I don't think that's the case anymore. It's going to move more, my understanding is going to move more
The-
down and to the left a little
The
bit.
original plan was we would construct a pad, we would be putting up a tent, say, in April, and removing the tent in September or October. We've done away with that now, and anytime there would be a tent, it would be a one-day tent like at Milton Academy or that they use for Curry College graduation, et cetera. So there'll be no tent pad there, there'll be no tent during the summer on a regular basis.
When the tent is utilized, Mr. Sheffield, where would it be located?
It would be
On
lo-
Exhibit B?
It
or
would be
Exhibit C?
located behind the house. If you look at that tab B, it would be located to the right rear of the house.
I just sketched it out rough, would you like to see?
I would, yes, please.
I just showed it to Mr. Hill. Obviously, this isn't the scale.
Yes,
It's the
sir.
short end here, and
Yep.
the speakers would be this way. facing
Speakers heading this
the
way.
gatehouse.
Yes.
Speaker heading down. You know, with respect to these event tents, has anybody, and I haven't been to a lot of events in these tents, but has anybody given consideration to the type of tent used? I know that they have these tents that can be fairly well involved, and they have drop-down walls and windows and doorways, as opposed to just a roof structure where it's wide open, and you could imagine that noise would be different in that type of tent than opposed to one of these sort of closed-down structures
you wanna
that I've seen.
I can. Typically, the tent rentals that we use for functions have the sides. It's very rare that it's simply a canopy.
Okay.
It's the tents with the sides. And we can make that a requirement.
Okay. Attorney Lipkin, you were addressing the 200-foot setback issue, and I heard you on that. Did you have any comment on the next part of the sentence there, of Attorney Hill's condition with regard to guests and event staff not using Chestnut Run for access to any of these events?
We all agree
We're okay with
that Chestnut Run will not be used for
Access.
access to people coming to the events at the museum.
Just to be clear, however, our H&E staff, and I don't know if any of you have been out there, there's a building out there that they use for equipment to maintain the grounds, that they need Chestnuts Run to utilize that, but that wouldn't be associated with these special events. And I believe that Brookwood Farm also uses that and has used that for some time. But I don't think that's an issue with anybody.
That's all I have, Mr. Chairman.
Okay, I have no questions
I
of
have
Mr.
another
Lipkin.
question.
Mr.
Going
Mullin,
back to
please.
this DEP issue. So, I want to talk about the guideline. Your letter says that the DEP regulation sets out a standard that's essentially a nuisance standard. And you say that there's no need to add the Board of Appeals to the mix of government agencies. But isn't another way to look at it simply agreeing that the noise guidelines apply? And that the Board of Appeals aren't seeking to enforce the noise guidelines, they're seeking to enforce their special permittee to comply with the noise guidelines. You see the difference?
I don't see the agreement in substance, because if it's put in a condition in a permit that H&E shall is bound, H&E shall comply with that. If they violate that regulation, you not only have a violation of the regulation and a violation of common law nuisance rights, you now have a violation of your special permit. So it's, I don't want to call it piling on, but it's really a third remedy, and it's just the practical way to deal with it, I would think, would be either with, I would think the health department deals with noise, that's who does in my town, or a private action for nuisance, not to come back to the zoning board and have it out here. But, that's my viewpoint. You'll decide. I think it's, the remedy is already there. You don't need another forum for it.
And it's clear in the CMR, and I'm referring to 310 CMR 7.00, it's 7.52, it says that any police department, fire department, board of health official, or building inspector or his designee acting within the jurisdictional area may enforce the Department of Environmental Protection's noise regulation.
If it applies.
Pardon me?
If it applies.
I proposed a condition. I mean, I don't want a noise condition that basically says thou shalt not be unreasonably loud. I mean, I understand what that means. And we
What's
can
the
agree with that.
citation, Mr. Sheffield, that talks about the,
310 CMR 7.52. And in reviewing the Walston Golf Course permit, there is a prohibition of unreasonable noise without defining it more specifically.
Mr. Mullen, do you have any more questions?
Not right now.
Mr.
Thanks, John.
Sheffield, do you have anything you want to add?
No, thank you.
Okay. So I don't have any further questions. Mr. Hill, do you want to be heard?
Sure.
If you want, gentlemen, you can stay right there, and Mr. Hill can move over here, and you'll have all your materials at hand.
Mr. Chairman, thank you for the opportunity to be heard, members of the board. I guess just starting from the beginning of my letter, first the premise, we recognize there's distinctions between events that are related to the museum and events that are not. And what I tried to do was carve that distinction. I tried to make that clear in our condition, that we aren't seeking to ask the board to regulate museum-related events. And there's a whole body of case law that governs that. There's land court cases, appeals court cases that talk about what's related to a Dover Amendment use. This isn't Dover Amendment, but the analogy is perfect. If it's related to the museum use, we're not going to, we don't have any right to challenge it. The board doesn't have a right to regulate it. If it's not related to the museum, it's a commercial activity, and it would not be allowed under zoning. So there's a distinction. There's plenty of case law that would guide anybody on this. And I really want to emphasize that I think we're kind of looking at this too literally. We're not, there may not ever be a problem. Mr. Lipkin stated, this organization has been in existence for 100 years. We've never been bad neighbors. We have a track record. Trust us. We want to trust them. And if there's not a problem, there's not going to be neighbors coming, knocking on your door to seeking to enforce the special permit or seeking to enforce the noise regulation. But I think it's reasonable just to put some parameters in here. And if it's related to the museum, we're not interested in regulating it or having the board regulate it. If it isn't related to the museum, we think it should be regulated by a set number of events. So we thought that 12 events per year was reasonable. I don't think we're that far apart. But we also think that that should include the indoor events. And Mr. Lipkin says, well, that indoor events won't have an impact. I beg to differ. And I think we have to look at first the setting here. This is a very unique setting. This is an estate where there's not a lot of trees. There's a lot of wide open spaces, and noise travels when there's nothing to block it. The member asked about the sides of tents. My acoustical consultant, who we consulted with on this, said the canvas sides don't actually make any difference at all. Sound goes right through them. Sound will travel unless it's really blocked by something that's solid. So in this case, we've got a lot of neighbors, and yes, they are far apart distance-wise from this estate, but sound travels when there's nothing to block it. So we are concerned not just with outdoor events, but indoor events, because at indoor events, the museum can accommodate, I believe it was set up to 99 people. That could easily be a wedding, some other celebration or function. People will be congregating outside on a warm summer night. I don't think it's unreasonable to say the 12 non-museum related events have to be capped at 12 per year, 1 per month. With respect to the term, we actually, I frankly don't think the nuisance remedy is all that viable. I have a lot of experience representing abutters and neighbors. That's really my practice area, is I represent abutters to projects. I've been doing it for 15 years. And I very rarely see a situation where an abutter could bring an enforcement action under a nuisance theory or some other theory, and a judge would look at the special permit. The judge would say, gee, there's a special permit that allows this. I'm not going to step into this. So I think this is really the first line of defense for us, that it's important for us to have reasonable conditions that we can say, gee, you didn't comply with this. We're going to go to the zoning board or first to the building inspector and say, you know what, we think there was a problem here last weekend. We'd like the building inspector to issue a letter to the proponent, to the museum, saying, yeah, there was a problem, don't repeat it. And hopefully that goes away. But I think that's the appropriate remedy for these kind of situations. We also think 2 years is an appropriate period of time. 5 years is a long time for us to wait to have a look back. I also don't like this open-endedness of anybody can come back at any time to modify the conditions. That leaves a lot of uncertainty for us, that we always have to be kind of looking over our shoulder saying, is the museum going to ask for a weakening of these conditions, for example? So we think a 2-year period with certainty is good for everybody. It's good for them because they know they have that they can do these events for 2 years, and we have the certainty of knowing that if there's a problem, we can come back. So I think 5 years is just too far. With respect to the noise, we thought that a 200-foot setback is appropriate. Again, it really has to do with the setting. You may think, 200 feet, gee, that's a very long distance. It is. But given this setting, I think it's appropriate. I don't think, looking at their site plan with 80 acres, I don't think that it's asking a lot to modify the parking somewhat by just pushing it further towards the Quinn Estate. We think the events, and again, I hear the concern about, well, what if a kite flies over the orchard, or what if the wedding party wants to have a picture taken that's within 200 feet? Look, no one's going to complain about that. What we're talking about here is the actual event. We're talking about the tent, the band, the parking, that kind of thing. So we're going to be reasonable just as they're going to be reasonable. We're not going to have a police. We're not going to have citizen policemen standing outside on guard watching to see if they trip over the 200-foot line. But I think there should be a line.
Could I ask you a question here? Because I may be wrong, and Mr. Sheffield would certainly know better than I would. But if there was to be a wedding at the estate with 100 people or 150 people, does the municipality require police officers to be present, particularly if alcohol was going to be served?
Oftentimes, the selectmen will require it as part of the one-day liquor license.
And does that depend on the size of the wedding or the location of the wedding?
It depends on the size of the wedding, and also it depends on the type of street it is. Usually the police chief, and we've met with the police chief. The police chief makes a determination of whether a detail is required or not. If he tells the selectman that a detail should be required, then the detail is just made a condition of the one-day permit.
Okay, so if
Never been an issue, never been a problem that I know of.
then perhaps the police chief would exercise his discretion early in the permitting process here to have a policeman present.
He may in the beginning or
So you don't have to
side
call the police. The
conservative.
police are already there
Yeah.
to make sure that things are in hand. I'm sorry, I didn't mean to interrupt, but that question occurred to me.
Sure. So going back to noise, we actually think it's a smart thing to do to reference the state noise standard. we're sitting at a table full of lawyers. You probably all got your Mass Lawyers Weekly news alert today that says that Governor Baker wants to put a sunset provision in all regulations that affect development. So, this noise regulation.
I think that's a little strong.
Well, your objection is noted, Mr. Mullen.
I read it, oh.
But I think there's a lot of criticism of the executive order that
I agree with that.
actually all sides agree that it's really poorly worded. But my point is that this regulation could be gone in a year. It could be amended. More importantly, we shouldn't have to go to DEP, which would be the ultimate arbiter of this issue, to enforce this. And Mr. Lipkin says, I like the term prohibit unreasonableness. What's unreasonable? I mean, I think that's a lot more vague. And I think having some sort of standard that we can all live with, that you can't increase noise by more than 10 decibels at the property line, above ambient. And I think if we say in the decision, this shall apply, then that's the rule.
You're really comfortable having the Milton Board of Appeals analyze and interpret this particular
If
bylaw?
that were ever to happen, first of all, it's unlikely. But if it were ever to happen and on a regular basis, these events are too loud every weekend, we're going to go out and bring our acoustical consultant to the site with a sound monitor and measure it. And then he'll come here and explain to you, here's the readings. So it's not something where you're going to be sitting in a position, what's more than what's not. You're going to have that feedback. But I think that's just a reasonable standard, and I don't see any problem with including it. I also don't see a problem with asking the museum to steer the speakers, the amplification, away from Chestnut's Run. It would be helpful, frankly, to have a plan that plots where this tent's going to be. I know you just sketched it, but I think it would be, for the record, I think it would be useful to have a plan that shows it more precisely.
But if you were directing sound towards I'll call it the gatehouse,
Yeah.
wouldn't that be of some protection for the neighbors?
Better, it's 90 degrees. I'd rather have 180. I mean, frankly, they own the Quinn estate, so their direct abutter is them. So I think it's better for the neighbors to have the sound going that way. And I mean, just looking at the topographical plan, I don't see a reason why they couldn't just face everything in that direction. It seems like where they're proposing to put the tent is relatively flat, so the way they orient it, I don't think makes a difference to them. I don't see how it would. But maybe it does, and maybe they'll explain that to me. But so we think that's reasonable. And frankly, when I talked to my acoustical consultant, it's actually Kavanaugh Tachi. I don't know if you're familiar with that firm. It's one of the 4 or 5 firms in the state that do this work on a regular basis. They told me that is by far the most effective mitigation of sound, is the orientation of the speakers. And they're actually working on a similar project up in Andover right now, where a farm is seeking to have events. And that's their main mitigation, is to steer the speakers away from the neighbors. And that reminds me, I kind of want to just give a little background of where we're coming from with this, because some people might think, gee, why are we making such a big deal about events? There is a concern, and it's not at all Historic New England's track record. We don't even know if they do these kind of events, but the point is that a lot of these kind of estates become convenient locations to have special events. And I've worked on a few cases around the state. In Natick, for example, Lookout Farm, they started having these winter festivals and October festivals and so forth to make the farm more economically viable.
Is that a profit-making venture? I think Lookout Farm is not charitable.
It's a farm. It's a Dover Amendment. Yes, it's certainly not making a lot of money, but it is a for-profit.
So it's a working farm.
Yes.
Mr.
But what they did is they built a train track, and it just became an amusement park, essentially, on a lower scale. We don't expect that to happen here, but it is a slippery slope. And so that's why we're here today, to say, look, we want some reasonable conditions so that there's no temptation to start having festivals and fairs and other things that could get out of hand in the future. Because we don't want to be fighting them. We don't want to have to go to court. And this is really the best way to do it. Get the conditions in here now. Everyone can agree to them, and we have some expectations of what's permissible and what's not. So we talked about noise, and I think that's really those are really the main areas of disagreement. We had the noise issue, the term, two versus 5 years, the number of events. We would like to see 12 per year, 1 per month. And we don't have, we're not seeking to limit their related functions. So if they have a fundraiser for them, that's not within our definition of special events.
But if you're having your special events, weddings in particular, you have a limited season for weddings, don't you? So if you say you can only have one event a month, that would mean that the applicant could only have 4 or 5, presumably, weddings there. Whereas I think the applicant is saying we should be able to have 12 events, but you could have up to 2 a month, so you could concentrate them in the better weather.
I realize 1 versus 2 doesn't seem to be that big of a difference, but it really depends on how it turns out. If these weddings in the summer turn out to be, loud and an annoyance to my clients, then it is a problem.
Sure, then we deal with it.
2
But
versus 1 is a problem. Yeah.
On the other hand, as Mr. Lipkind has indicated, that the weddings may be an important factor in keeping this particular segment of HNE financially viable.
Yep.
In fact, you probably saw the article in the Boston Globe talking about the zoos on the North Shore this morning. It was a front page article that they're not able to raise sufficient monies from admission fees, and they were looking to have events and looking to have fundraisers and have benefactors boost their ability to maintain their infrastructure. So I guess even though this particular H&E may have 36 or 37 particular buildings and areas where they're protecting and preserving, if they look at them all on an individual basis to see if they're self-sustaining, that may be a factor here.
Yeah, and we can understand that. I think it's appropriate to have some weddings. From what I understand, they're only going to be allowing their own members to use these facilities for these events. So it's not like I could go up to them and say, "Can I have my wedding there?"
Is
that's
that true, Mr. Lipkind? I didn't understand that to be true.
I would say that Diane could speak to that, but it's not written in stone. But what we were considering was only making it available to their. I don't know how many charities you're involved in, but there are members, and then there. No, I'm sure it's more than me. There are members, and then there are members. And this would be for the
Top tier.
higher level of membership. I don't know how they.
So I can't send in my $100 and then have
Exactly
my daughter
right,
married
right,
there
yeah.
next year.
Right.
Okay, so it's for the principal benefactors of the.
I don't know what the words are they used to describe it, so I don't want to throw any out there, but there are different categories of membership, and this would be for the higher ones. I don't know what the lowest level membership is. Maybe it's $25 or $50. That doesn't give you the right to have the wedding at,
Otherwise, the membership is going to go through the roof.
right.
This
That's
is a
not-
very attractive site.
Right, right. So that's what Mr. Hill is referring to. He did
Okay.
discuss that. He's absolutely right. I don't know that it's cast in stone as to which level of membership it would be. We don't want to make it so, you get all these people paying $25 so they could have their wedding, or $50. I don't know what the minimum.
Okay, but the intent is the higher level of benefactors
Correct.
of H&E would be eligible to have
That's right.
weddings there.
Yes, it's,
That-
what we had offered during the negotiation was our Appleton Circle membership, which starts at $2,500 a year.
Yeah, but we didn't,
It's our highest level.
we didn't,
Still a steal.
we didn't want that cut in stone, we want some flexibility on that, but the thought was that it would be for the premium levels of membership. We don't, 10 years from now, there might not be an Appleton Circle, there may be some other
Or
circle.
it's equivalent, whatever the equivalent is.
Yeah.
Do you think, Mr. Lipkin, that if you limited, particularly weddings we're talking about here, and not other events that you may have outside of the principal building, and they were limited to the Appleton Circle folks, that you'd have less likelihood of a violation of unreasonably loud noises, and you'd have a more
That's-
stable group of people at the
That's a
wedding?
very dangerous path to go. I've
It
seen
is.
people with a lot of money make fools of themselves, and I've seen people with no money make fools of themselves. So
Well, and-
that may be true, but I don't know.
Well, you may have
I
more,
can't agree to
you
that
may
one.
have more control over them, let's put it like that, but I don't, maybe you don't. I
But it
still,
would certainly limit the people who would be eligible to do it. I wouldn't want to handcuff them to say it's just X category of membership. I'd rather say it's just the premium categories of membership, just so they have some flexibility.
I'm not sure if the governor of the Commonwealth wanted to have his daughter married there or something along that line. A special consideration might be given.
I don't think so.
Well,
That's definitely a violation of the ethics law.
well,
2,500.
aren't Governor Patrick's daughters married? I know one is married. Is one still single?
I think they're both married now.
Mr. Hill, I'm sorry. Do you have any?
Just
anything
one
else
last
you wanna
point.
add?
On Attorney Lipkin's proposed condition list, one of our concerns was just the definition of special events, and I think that's a major point of contention between us. You know, his definition would say that special events are those that are events that are where the use of property is rented by Historic New England to third parties. So again,
And that's not, and there's sound amplification.
Yes.
right.
That's the
Exactly.
case.
So there are limitations there that I don't think are appropriate. I think special events should be broader to include any non-museum related function. So number one, it shouldn't necessarily be a sound amplification. That's obviously a major concern of ours, but that isn't the only source of noise. Rented, Historic New England might,
Well, but if there's no sound, I don't want to be difficult with you, but if there's no sound amplification involved, wouldn't is it the Woodbrook, the Brookwood farm that's operating back there? They'd cause more noise than any of the kids running around or flying kites or doing activities that may not strictly be museum directly related, but wouldn't that be true?
but they've been there. I mean, they're an existing use.
Well, some people would say this building has been there for a long time as
Yes,
well.
but not as events. That's the difference. It's been a private estate.
Well, but isn't one of the difficulties you run here is making rather subtle distinctions as to what benefits the neighbors, what's the type of protection they need, vis-a-vis unduly restricting the applicant and finding out the applicant says this isn't viable, it's too much of a pain in the neck, and selling the property, and you find 100 houses going onto the hillside up there. Isn't that the balance?
I think you're right. I think we definitely prefer the museum over a subdivision. But I don't think that our conditions are the kind that are going to force Historic New England to say, gee, this is too much, we're going to sell this. I mean, I don't think they were counting on hosting special events, and this is just sort of a frosting on the cake. If they can make some money by doing some weddings over the course of the year, then that's great. I mean, that's why I put the information in my letter about their financial condition. I think it is relevant. So I'm not concerned that our conditions are that onerous. And I also think that, it's problematic to say these events are only the ones that are rented, because Historic New England might allow somebody to have the use of the property for free, which could be an event that's hosted by a different nonprofit that has a fundraiser. I mean,
It could be the trustees of the public library, or it could be
Yeah,
the
exactly.
students from the high school.
And also the word third party. I mean, if they're leasing the property to one of their members, is a member a third party? I don't think we should get into those kind of limitations. I think it's much more cleaner to say, if it's a non-museum related event, it's a special event, 12 per year.
Okay. Do you have anything else you'd like to add?
No, sir.
Okay. Mr. Lipkin, do you want to respond to that, or should we see if any member of the public wants to?
Just briefly, the 200-foot.
Oh, I'm sorry, Mr. Mullen has a question, excuse me. Mr. Mullen.
We didn't talk about distinction between events based on the number of people that are there. Isn't that important? And doesn't that matter in terms of this distinction between special events, amplification, et cetera? We're really only talking about special events at which you're going to have a large gathering. Is that not the case?
I think that's implied. We didn't put.
It's implied?
Implied, yes.
Well, it may make a large difference, right? Because there could be a lot of events that are really no mind, especially if you're not drawing a distinction between indoor and outdoor events. So Is there a number of people that we can begin to talk about? I didn't come up in either of the presentations, and I don't, perhaps that's not a fair point, but,
When we were discussing this with the prior attorney, we suggested that there be a prohibition against events having more than 200 people, so that you couldn't have a wedding with, 250 people, regardless. We have an inside limitation of 99 for occupancy standards. And I would imagine that most of the events would be 150 or fewer.
If you look at the special, that the conditions that both Mr. Hill and I drafted, I'm looking at mine. It says special events. Again, we define special events differently. But mine says such events shall not be open to the general public by invitation only and shall pass. So the special events, which I think of as rentals to third parties, weddings and the like, have that limitation in there. I don't think there's another express limitation. There's a natural limitation in terms of the amount of parking is limited. I don't think we're planning on having a Woodstock festival there, but that's where if the natural concern of the neighbors, or I think the reasonable concern of the neighbors is noise, the unreasonably loud condition would seem to cover that.
it just seems to me so fundamental, given the distinction between amplification and non-amplification. I mean, if there's a special event with 20 people attending, that's a very different event than one with 200.
To me, if there's sound amplification, it's limited. If there's no sound amplification,
No, I know, we're trying to just we're trying to explore ways that we can, so,
Right, but what if, Jeffrey, if they have a kite flying festival and 125 kids show up and they have their parents and their grandparents and whatever, you could have 250 or 300 people.
yeah, my sense is that those events are very difficult to plan and are probably going to be very few. I think that there's going to be many more events. I don't actually like the word rental. That doesn't seem to me to be, it's use. So this is about use, right? It's not about rental.
well, rental is...
We don't want to get into your business, and I don't, I want to be careful to say, look, you have to show me that it's a rental, and it starts to get, I think, just much too complicated. To me, this hearing is about what the last hearing was about, which is what's the intensity of the use, and we're really trying to get at that, and I'm still don't fully understand it because of this issue. So I'm interested in the volume of people. I'm not interested in the legal arrangement between the user and the owner. I'm not. I don't think the board should be. Doesn't matter whether you're renting it. It matters whether they're using it by a third party for a non-museum use. And the real question is, how often is that going to occur? And when it does occur, how many people are going to be up there? And I don't have a good sense of that from this conversation. I hear from the neighbors that they want to limit that to 12 per year, 1 per month. And I'm hearing from the applicant, 12 per year, 2 per month, but it's only those events that have sound amplification. I know that's a shortcut. That's a shortcut of doing it, but, and I think there's a wide, I know you're saying that there's not much room to go, but I think there's a lot of room in between those two positions, so
Well,
that's what I'm trying to explore. I'm sorry, go ahead.
I'll try. I think watching the tape of the last hearing, I think what Ms. Vieira said was, in addition to weddings and things of that sort, which would be a noise concern to the neighbors, they might use it for a gala,
Yeah.
maybe once a year. I put twice in there just in case. And that I think would be it in terms of sound amplification outdoors. Indoors, I still don't see the concern. But if you're concerned about outdoor fairs and things like that, where there might be a quantity of people outside, there's going to be the opportunity for the public to walk around the property daily, I thought, when it's light out. So there may be people walking around the property. I don't know that they anticipate a great volume, but in terms of having a kite flying fair or an Easter egg hunt, I can't imagine that there's going to be a lot of noise from that, but I also can't imagine they're going to be doing a lot of those each year, because they do take some organization to put together. And I thought she had said the kite flying fair was maybe once a year.
We estimate 3 of those types of events a year, what we would call an outdoor public event. I'm not sure I understand what the definition of fairs and festivals is on both sides, but if I call it a kite festival or a kite fair or a kite gathering, probably 3 of that type of activity per year.
I'm really trying to not do that. I'm really trying to say it's either mission critical, related to the museum, as you've indicated in your application, or it's not.
Well,
And leave it at that.
Those things are mission critical.
And I understand they could be.
Yeah.
Which we may not be talking about those.
Yeah.
That's a whole nother issue.
I was just trying to help out on the intensity of use, and that's one use to which the property might be put. I didn't think that Mr. Hills or his clients had an opposition to that sort of related to the museum sort of function.
No, he made that
And I was
clear.
trying to get at special events with things that aren't directly related to museum function, other than fundraising, and that would be having those rental functions. That's why I had rental in there.
Yeah.
Anything else would be more in line with central to the mission sort of thing.
The other thing is there will be landscape tours that may attract 20 people, but they'll be going around the entire property and
But those we're not really talking about, because those are related to the
the
mission.
mission.
Yeah.
Well, then I'm really not sure what you're talking about, because the only thing that's not going to be directly related to the mission would be these rentals for weddings and things like that.
This
The
is
kite flying-
exactly why I'm asking why it needs to be 2 per month and 12 per year. It's exactly my question.
Why does there need
Seems
to?
very narrow.
Well, we'd be happy to have more. We limited the number to appease the neighbors.
No. When I say it seems very narrow, there's a limited number of functions that fall into this category once you take away the mission-critical activities, it seems to me. And my question is, how often are we going to have the type of activity that's going to rise to the level of an intensity of use that is, and I'm asking both parties, that would cause concern?
I thought you were excluding from that category things that are kite flying fairs and things like
I
that.
didn't say anything about kite flying. I want mission critical or not mission critical. I don't know about the kites. If the kites are related to the Eustis Estate, then they're related to historic New England's
They are.
mission. But it's not really our business, I think, the Board of Appeals, to dictate what the mission is. We've got an application in front of us. We've got your letter. We know what historic New England will and won't generally do.
Yeah.
And my sense is it could be a couple of years from now where somebody's going to come in front of us and say that there was X event that was not related to historic New England's mission, or it was. I would much rather have it at that than for us to dictate now that a kite festival is or it isn't related to the Eustis Estate.
And I
You know what I
think
mean?
I think we're in agreement that there's some elegance here to leaving things sort of unanswered. And I think I think we all acknowledge that we're not tonight or as part of this proceeding going to try to narrowly define every single possible event that
Right.
could be regulated.
Yeah. That's all.
Fine.
So if you say we're only dealing with activities that are, for just to shortcut it, non-mission critical, because those are the only issues that the neighbors have expressed a concern, and I haven't heard any independent concern of the board, although that might be here. Let's talk about those. And are we really only saying this?
I thought the concern of the neighbors was noise.
Well,
And I thought that was the concern, and that's what I'm trying to deal with. If someone is using that facility for as we said, the facility might be used for a community meeting and partnership as a venue for collaborative programs with other community groups and meetings which serve the community, is that mission critical? I don't know. If we provide a forum for other nonprofits to come in and use our hall, I don't know, but I do know the neighbors are never going to hear it. So that's why I thought noise is a good way to go. And
right,
Someone-
I agree, I thought noise was the issue. But I think Attorney Hill, you've represented that you're 12 per year, 1 per month. is going to include indoor activities.
Right.
And I just think that's pushing it a little too
But only
hard.
non-museum related.
Well, who's going to be the arbiter there of what is and what isn't?
I mean,
the burden will fall-
Last week, we had 50 people representing all the nonprofits in Milton, from, Kerry College to the Rotary Club, et cetera. And they loved the invitation, and they loved, being there, et cetera. That should be mission critical, in my mind.
The burden will fall on us to prove that it's not. I mean, that's how, I think that's the standard under the zoning act. And so if we think that, if there was an indoor event that was so obnoxious that we cared so much to come before you to say, this couldn't have happened, this is not mission critical, this is not incidental to their primary use, then you can be assured that we're gonna come forward with a bunch of evidence that proves that. And if we can't prove it, then we lose. And if we want to appeal it, we appeal it, if we really care that much about it. But I think it goes back to the point that we're just laying out some markers here. We're not necessarily going to say every indoor event we're going to jump up and scream about. It's only if it's going to be an indoor event that's probably a wedding or some other similar kind of function with 100 people, and it's noisy, and we're going to say, that counts, that's one of your 12.
Well, what you do then is you discourage the use of this iconic facility to allow other nonprofits to use it for a meeting where there'd be no impact on any of the neighbors. They wouldn't even know it happened. None of them called up complaining that 50 people were there last week. I assure you, if there was a noisy wedding at 11 o'clock at night, you would have gotten a call. And I think that's appropriate. That's an appropriate consideration for the board. These outdoor speakers, it's going to wake the neighbors up, whatever. Sure. Put a limit on that. Do you really want to discourage the use of this facility? I don't think so. I mean, the selectmen were all in favor of it. I quoted the part of the master plan that I did for a reason. It was HNE's intent to use it as a cultural facility offering tours, accommodating scholarly activities, and hosting events. I don't know whether that all falls strictly within an architectural museum, but there's no impact on the neighbors.
So I want to move off. I have a couple more questions. So you would say that having the distinction between mission-related, museum-related, incidental to the primary use and not, isn't really the distinction. It ought to just be on noise.
Or nuisance factors.
I think that's the easiest way to enforce it, and it protects the neighbors the most.
Okay. On the, can I ask?
You have more questions?
I do.
Mr. Milton, you have the floor.
On the term, why is it not the case that a 5-year term would incent the historic New England to comply so that they could stay up there? I'm not sure I'm following that. And why just the 2 years?
We just think 5 years is a long period of time to go without having a
I don't know
check-in.
that it's a long period of time for a place like historic New England, is my point, Where are they going? Given their level of investment. I just put that out there. I mean, usually a special permit that we grant will say it's subject to reasonable conditions that the board may impose from time to time. There's a fair bit of pressure on special permittees in this town to comply with the permittees because of that. And it's bilateral, I mean?
Mm-hmm.
Anyone can bring people up. So I've seen it both ways. I've seen that condition, and I've seen a term, and I've seen both. And we just had that situation with Eagle Farm. It just seems like in 2 years we'll be all back here and doing this, having the same. Maybe we won't. I don't know.
Well, I think that, just to put in perspective, what we're talking about here is just simply the commercial special events. We're talking about renting or letting other people use the estate for parties. We're not talking about anything else. And we just think that segment of this should be reviewed in 2 years.
Yeah. Okay.
And if you wait 5 years, then we've got 5 years or 4.5 or 4 years worth of events that we as the neighborhood, we can come in and complain about them, but we don't necessarily have, there isn't a process set in place to potentially amend these conditions.
Well, you could
I'm
be.
not- I'm
yeah.
not sure of that.
Yeah, I think you'll find that well, I don't want to speak for the board. On the, another
Well, you
question?
could amend your,
Ask as many questions as you
okay.
want.
you could amend your own my understanding, and correct
Yeah.
me if I'm wrong, you may have your own practices, but under the law, you could amend your own conditions, but we as neighbors couldn't ask you
No,
to.
what we see is a neighbor will seek enforcement of the special permit by the building inspector. The building inspector will then ask the Board of Appeals to issue a ruling, and we do that fairly
Right, but
often.
they could be in compliance with these conditions, and it could still be a problem. And that's
Could
the,
be, and
that's
we've had
the
that
issue.
too, and we've decided whether or not it's a problem or not, you know. On the regulation, the DEP regulation, if you're pointing the speaker at the Quinn Estate and you're measuring at 10 decibels at the property line, aren't you pointing the speaker right at the place where you're going to measure the noise? I mean, the closest property line is Quinn's property, you know, and I actually, you know, it's kind of an interesting site, given the size of the site. Measuring at the property line is a fair standard, but not if you're pointing the speakers at the property line, you know?
Well, hey, look, we're not concerned about the property line at the
No,
Quinn
I know,
Estate,
but that's the
so-
standard in the reg, right? It's going to be, you're going to be measuring the noise at the property line, aren't you?
But we would have no standing to argue about that, since we don't own the Quinn Estate. So-
No, but we're setting ourselves up to violate the reg that we're laying it. I like the standard in the reg because it's a bright line, and I can see, just based on this hearing, we're going to have a conversation about what's unreasonable, what's reasonable, and maybe that works in a town like Milton. We don't have a lot of this kind of thing, and this is pretty unique, I have to say. So, but it does sound counterintuitive to point the speakers at Bob Quinn's house, the Attorney General, and then have, you know, he was the Attorney General after all, and then use that to violate the reg. It just, there's got to be a different way to do that, so,
Well, I think you could, in your condition, carve that out as an exception, that since they own the property,
Yeah.
that is not the property line for purposes of this enforcement.
We own the property, we bought it for defensive purposes, we do not plan on retaining it. And it will be, we expect that it will be ultimately sold, but with restrictions on it.
Yeah, I think for this board to say the speakers shall be pointed at that house, when we could point it towards Canton Avenue, and maybe there would be no unreasonable noise impacting anyone, and that property line is so far away, I don't see why the board should get that into that level, what I think is micromanagement. There's a reason why you haven't had these sorts of disputes in this town or in most other towns, because people try to work them out.
I don't have any further questions. Thank you.
Mr. Lundbaum?
No.
Okay, let me, the attorneys have had their say. Let me just see if there's anybody out there, a member of the public who wants to be heard. Just please indicate. Yes, sir. You're going to have to come up here, Mr. Shillingford. You can't, we can't hear you back here.
My name is John Shillingford, 1386 Canton Avenue. I'm the last man up Chestnut Run. I heard you mention earlier that people were principally considering the noise element, which is a feasible argument. I'd like you to use your imagination to envision what might happen here. These people have, New England Historic has said that one of the assets of the property is to have people, principally in the daytime, I would guess, look around the estate, right? It's a magnificent estate. They speak of 80 acres. Only about 30, I would guess off the top of my head, about 30 acres are pertinent to any people that might want to wander around. Up the farm and then back of my place is all relatively rough country. I don't think many people are going to go up there. However, during the daytime, people might be encouraged to look around the property, which is lovely. One of the assets of the property which they might look at would be the pond. Now, do you have I don't know, most people have a map here. can anybody know where the pond might be there on the maps?
Look like there are several bodies of water back there.
think it's
If you look up Chestnut Run.
Yep.
The orchard, which has been discussed, is on your right as you go up.
Yes, sir.
As you go up, and then there's a field to your left, and there's a pond there.
Yes, there is.
Yep, and there's also a semi-formal garden which Libby Eustace has put considerable effort into, which makes the site more attractive. There's what I think is an ice house down there also, an old stone ice house. Now, if people should walk around the property, that would be an appealing place for them to go. Now, that would presuppose that they would walk past the orchard, which is a lovely spot in itself, and the rhododendron planting on the hill right next to the orchard, and then they cross Chestnuts Road, Chestnuts Run, if you will, and they go down the field to the pond and wander around down there, right? Now we have a significant portion of the guests possibly going back and forth across Chestnuts Run. Now, of that, there would probably be a few who would be curious to go up Chestnuts Run and see all the fortunate people that live up on Chestnut Run. So now, what we're talking about here is what has been a historically tranquil scene enjoyed by the neighbors, which all of a sudden we're going to have a relatively uncontrolled group of people wandering around. Now, is my point made?
I'm not sure what your point is, because the way you're describing this, they would be on property of HNE. They're invitees of the estate, so presumably they could pass and repass on the road. They wouldn't have the legal right to go off of the
I'm not
road
disputing
and
their
go
right-
onto your property.
I'm not disputing their right to do it, right? But what is involved here is not just the noise of a party that's over on the other side of the hill. What's involved here is people at these events wandering around across Chestnuts Run, and maybe a few of them up Chestnuts Run to see who lives up there and so forth, right? Contingent of what this impacts is the number of events that are had and the number of people that are at those events. Now, if this is a regular happening every other weekend in the summertime, it's a nuisance, or it could be a nuisance.
Well, you could, I don't want to be argumentative, Mr. Shillingford, but you could reverse that argument and say that people who are coming up Chestnuts Run to visit your property are causing noise that somehow is affecting the estate. This is the estate's property. Am I wrong? Does the HNE own Chestnuts Run?
question. No, I don't dispute
They own the
I don't
fee.
dispute the right at all.
Okay, all right.
What's pertinent here is how often is these events going to happen? I mean, it's somewhat of an inconvenience for us to put up with that, if I may use the word put up with it, right? I'm not disputing their right to do it, right? But if this is going to be a constant event with people wandering around, you can imagine that the peace is disturbed.
Okay,
Okay?
sure, thank you. Is anybody else who'd like to be heard? Okay, the record indicates there's no such person. Oh, yes, sir, come on, come right up here.
Hi, I'm John Seidman. We live next to the Suffolk Resolve House.
Sure, I think you spoke
We
at the
spoke last
last,
time, yep.
what's your address, sir?
1350 Canton Ave.
Good, welcome back to the Board of Appeals.
So I just wanted to clarify one point that I think was raised here, or at least clarify, at least in my mind. My understanding, your argument, you made the argument that this fundraising might be necessary, money-making might be necessary for the activity of this museum, for this estate. I just want to remind or just ask, so my understanding is Historic New England has 36 sites, and of those 36, I believe 7 of them have events of the type we're talking about. So it seems that 29 can get along without this activity.
Oh,
So-
what do you base that on? I don't think we've had any evidence to that effect, at least I don't remember it.
I base it on what, if you go to the historic New England site and ask and look to where you can make, and we can ask, if you, please correct me if I'm wrong. But my understanding is that you can do, that 29 of them don't have weddings and 7 do. So it's not every site that requires this activity. So I just want to clarify that we shouldn't be thinking that this is a requirement of these museums.
Do you want to comment on that, Mr. Lipkind? Is that true or not true?
I
or-
don't know, I just know that this was a pretty expensive site, and it takes money to buy such a site.
The other
Okay.
thing is some of the other sites are single buildings on a small lot, which would not be conducive at all to having a function, and you would have no functions there.
Anybody else would like to be heard? Yes, sir.
Hi, my name is Peter Jeffries. I grew up next to the Eustis Estate. I live at 67 Vos Hill Road currently. A couple of things, and I wasn't at the last meeting, so I don't know if Curry College and the noise from Curry College that is evident in that neighborhood when they are doing a function, just to give everyone...
That did not come up at the last hearing.
When they're doing something at Curry College, and if you look at the site plan, you can see where Curry College is, the main driveway shows. And it's across Canton Ave and Blue Hill Ave. So it's quite a ways away. And the sound does carry. So I just wanted to point that out. So when there is a function at the Eustis House, as was pointed out before, the sound will travel. On page 5 of the letter from Mr. Lipkin, there was a reference to the Wallaston Golf Club, the Hoosick Club, and the American Legion Hall, and the fact that they do quite a number of weddings,
Wedding reception.
wedding receptions there. And I'd like to point out that they, to my best of my knowledge, they've been doing those for years. And the neighbors have made a choice to live there and to be acceptance of that activity. I spoke to a neighbor of the Milton Hoosick Club who has lived there 5 or 6 years. She made a choice. She was fully aware of what was going on when she purchased the house, made a choice to accept it. In this case, with Historic New England, this is a new use. And I think it is incumbent on the board to take that into account and go slowly with the permitting process and the number of events so that the neighbors can get a feel for how it will be. And, you know, I fully support Historic New England buying the property and using it, and I understand their needs. But, and I think it's great, and it's much better than having house lots there, though I should add that 35 acres of that does have a conservation restriction on it. But I think that going slowly in terms of the number of events, so everybody can get a feel for how it all works out, and then in 2 years, or maybe 2 years after the museum opens, would be appropriate for a review period, a look-back period. So, thank you.
Great, thanks, Mr. Jeffries.
Mr. Leonard?
Yes, Mr. Lipkind.
Can I address something that Mr. Jeffrey said?
Of course you can.
Just with regard to the 2-year period, planning events, especially a wedding, can take, sometimes they're planned more than a year in advance. So if a 2-year limit is imposed upon us now, in reality, we're not going to be able to use the space for that function.
Thank you. Anybody else would like to be heard? Okay. So there is nobody else who wishes to be heard. Counsel, are you all set? Have you said your piece?
I'm all set.
Great. Okay, so we'll call an end to the evidence portion of the hearing. And yes, it's our obligation under the open meeting law. It's our obligation to decide this in open session and discuss it in open session, and we intend to do that here and now. Let me start out just by saying that how much the board appreciates the hard work of the lawyers in this particular case. I thought that Mr. Sheffield always is enormously thorough, has presented a wonderful application. Mr. Lipkind, this is one of the areas of his expertise. We appreciate his comments and his hard work. Mr. Hill has done a wonderful job at both hearings and has provided the board with a compelling letter with his view of this. And I just think it's a credit to everyone that everyone here acknowledges that this particular HNE, some refer to it as a gem, as Mr. Hill does, historic. It's a significant, the selectmen have told us, and the Milton Historic Society have talked about how significant it is and how important it is to have HNE here and to have them successful. So I think really everyone here has acted in good faith, representing different interests, obviously. And I just want to tell all of the attorneys present that they did a terrific job on behalf of their clients. Their clients can ask for no more. I know good lawyering when I see it, and I have seen it here. I'd also like to thank the neighbors for their participation in these hearings, more at the last hearing than this one. Always amazes me, and I think it's a credit to the town, but it's also a credit to the neighbors that people can discuss issues that are as personal as the use of real estate that's next to their home, that's going to be a different use than previously, how they can discuss the issues objectively, in good faith, and in good spirit. And I saw that here. It's remarkable. Some of the variance hearings we have can be somewhat difficult, and everyone here has, I think, comported themselves with dignity and with good faith, because everyone wants this project to work. So I think everyone's worked hard. The hearings have gone well. And there's a lot of agreement here when you look at the basic issues. We're differing in a couple of substantial areas, but there's a lot of it that's nuanced that the board is called upon to decide, and that's why we get appointed to do these things. So I have said my piece on all of the preliminaries. Mr. Mullen, do you want to be heard? You don't want to be heard, that's fine as well.
No, so this is really tricky. Is there no special permit in place now at all?
Correct.
Nothing, yes.
There is conservation permits and, other types of permits.
How long, I know that the property was purchased in, what, 2012?
2012, and the residents, Libby, the Eustaces, were allowed to live there for 2 years after the transfer of ownership.
Yeah.
And during that time, it was residential, and it was only after that they left that we applied and obtained charitable status from the Board of Assessors. And of course, that has to also be ratified by the Board of Appeals.
Yeah. So the reason I ask is I was struggling with this issue of the distinction between museum use and non-museum use, and actually the Board of Appeals jurisdiction over the matter. But it seems to me that we've got jurisdiction over the entirety of the use, given the fact that the charitable nature of the use is subject to the issuance of the special permit.
Correct.
And that makes this very timely, given Commissioner Prondak's letter. So let me just, I think this is a matter that calls for a bit of a conversation, if that's okay, Mr. Chairman.
With whom are you going to
No,
converse?
with the board.
Oh, that's fine, sure.
It seems to me.
Well, look, I agree with you, Jeffrey. I think there are nuances here that need to be fleshed out, and nobody is I asked Mr. Mullen to speak first, and I'm glad he took me up on my offer, because many times in these hearings where you're running the hearing, you can be perceived as taking over too much of a role. So I tend to like to run the meetings, ask questions, but have the other board members take the lead. But in doing that here, I asked Mr. Mullen to speak, not that he was going to dictate a decision to us, but that he was going to talk about his views of the positions of the parties so that the other board members, including myself, could discuss them and come to some consensus. So why don't you proceed? We're delighted to have a conversation with you anytime.
So I've been sitting on this Eagle Farm case for
So have I.
15 years, right, Steve? And we've had many hearings on Eagle Farm, and that's a much beloved, in the main, facility in the town, and people appreciate having it, I think. It's on a busy street, but there have been a lot of issues up there. I think Mr. Jeffries' point is well taken about trying to go slow and trying to establish a track record. And that's been my experience, and perhaps Steve's as well, in observing the things that have happened at Eagle Farms over a long period of time, certainly longer than I've been on this board, going back to the 1960s, as you know, Bob. So that's one thing that's on my mind. I don't like varying the board from the typical standard of being able to modify the special permit from time to time and subject this to the enforcement of the building inspector, notwithstanding the concerns that were expressed about perhaps that being risky. It seems to me that's on both sides, and that's very appropriate for something that we're just starting out with. And I also think a term is okay. I might not have said that if the applicant didn't agree to it. I'll say that. But I think in this case the term makes sense. But 2 years I think is a little short, particularly given the track record that has been established by Historic New England and the fact that the special permit is subject to continual enforcement by the building inspector and by a hearing of the Board of Appeals. And we don't lack for sitting in this room and hearing these cases. We've certainly done it enough. So that's the third thought. The fourth thought is I like the DEP regulation. I don't like to enforce the DEP regulation, but I like the standard in the DEP regulation. And I think measuring the decibels and getting away from something that's reasonable or unreasonable, particularly after the fact, is going to be really difficult. Not getting away from it, but trying to determine whether the noise was reasonable or unreasonable is difficult. But adhering to the standard in the DEP regulation, I do think having something where the applicant is obligated to take steps to minimize the noise on the neighbors is reasonable, without dictating the degrees to which the speakers need to be facing. Again, Mr. Jeffries' point about, I'm actually pretty familiar with the layout here and the hill, and I'm not sure I would have predicted that the Curry College noise, although it's directly across from the hill, from the museum, as the crow flies, it seems to me, if you walk through that property, you'd be right at the circle off of Blue Hill Avenue. I would think it would be more typical that the noise would flow downhill rather than uphill, but the fact that it flows uphill is interesting to me and really just reinforces the fact that we should have some type of standard, and because we don't know anything about noise, DEP does, that seems to me to be reasonable. And I'm not saying that the Board of Appeals wants to get in the noise business, but it seems to me that we could have a conversation about whether or not the noise was violated and rely on the Commonwealth standard. In terms of the related or not related to the museum, I'd like to try to keep that simple if we could. And what I'm hung up on is the non-museum number of events, limiting those while at the same time not drawing a distinction between museum events that emit sound and those that don't. So I'd like to maybe have a conversation about those, about that issue. On the rental, I already commented on the rental. You can tell by my comments, I really don't want to get into, and I don't think the town has any business getting into historic New England's business. And this isn't about rentals, it's about uses. And I'd prefer to, and I'd encourage the board to stick to that standard. I like the offer of a premium membership because I can see this being a fairly popular place. And I read Kathy Heater's letter, and I thought that it was very well done. And I can see her concern along with Mr. Schillingford's concerns and the concerns expressed by the Seidmans, not at this hearing, but at the earlier hearing. So those, I think, that really is the extent of my comments at this point, John.
Okay. Mr. Lundborn.
Thank you, Mr. Chairman. Jeffrey, could you just touch again on your thoughts on, in terms of use, as opposed to defining what is and isn't a museum function? I wanted to just hear that again.
I just thought that the number of events, I thought what I heard from the neighbors was that the number of events would be those not related to the activities that were central to the museum. And I would say that we could say that as expressed in the application, which I think would include your letter.
Yes, that
went-
makes sense.
Alan, you went through that in your letter.
Yes, I did.
Yeah. And they said 12, one per month. The applicant said
12, 2 per month.
12
Up to two.
events at which sound would be amplified, 2 per
Yes.
month,
Yes.
whether it be related to the museum or not. That's what I heard.
Correct.
Well, other than the members, the preferred members would be the ones having the wedding.
Well,
So that's somehow related to the museum.
no, that's a different condition. That condition would be if, in order to use it for a non-museum event, you'd have to be a member of a premium membership associated with the applicant.
Yes.
But that's a different condition, right? This condition
I
about,
think they're related. But
well, they are related in the sense that that's the user class. In order to be a user, this is confusing, and I'm making it more confusing. Part of the confusion is I think we've got a little bit of a different explanation of and, we need a matrix, and we can't draw one because we don't have time. But the applicant is saying that it's all events, any event that's held at the museum, whether it be museum related or unrelated to the museum. But they have to be amplified by sound and held outdoors.
that's the trigger.
Isn't that right? Yes.
I didn't know if you were allowed to participate.
Well, no, I
Should
mean,
close the
please,
hearing.
because
If
it's
you look-
confusing to me.
I understand.
Yeah.
Maybe I didn't do a good job.
No, you did great.
But I'm looking at my compromise conditions, and we have a numerical limit on outdoor sound amplification, what I call rental events to third parties of 12 per year, two per month max. And then I have under museum operations, category B, those wouldn't be considered a special event, subject to numerical limit, but if Historic New England is going to use that property and have an event with sound amplification, it's scheduled to the same time, 10 a.m. to 10 p.m., that sort of thing. And same sound, can't be unreasonably loud.
Right.
I'm just looking at page 1 of my compromise conditions.
Yeah.
I just don't want
Okay,
to.
so here's the issue, right? So one of the problems is your conditions don't really line up They're not, they don't mirror each other. It doesn't seem like the neighbors have responded to the second condition that you expressed, and that's something that I've been struggling with. So I'm sorry, Steve, maybe it didn't help you, but I was trying to make it simpler by speaking to this only related to the museum. Maybe that's not possible.
Yeah, we've got to find a way, because my fear is we're going to get caught up in this, trying to define
Yeah.
what is and isn't museum-related. But my overall notion and feeling here, the last two meetings, is that the neighbors are supportive. And I'm not so sure, and Attorney Hill, you've done a tremendous job, but I'm not getting the sense that the neighbors are perhaps looking for these clear, bright line definitions between what is and isn't related. Their concern is noise. Their concern is intensity of use. So I'm still trying to, in my mind, get an understanding of which way we can go with respect to which event is. I think we sort of need to get away from trying to define which events are museum-related and which aren't, because you just get stuck. In the overall, the best thing that I did is I spent some time up in the estate this weekend.
Great.
Drove around, walked around, and really got a sense. Hopefully, I didn't trespass on anybody's property.
Not at
I may have, but I took some time, and I was really struck, obviously, with the size and the scope and the beauty of the estate. My sense in terms of sound, for example, and these outdoor events, and the layout and the topography and the way, to me, the affected abutters seem to fall down a slope, and they're to the front of the building, and the idea here is to have these events to the rear of the building. And you've got significant trees, historic, well-developed, very large trees in that sort of natural buffer area to the front of the building. That's just my observation. And I think Attorney Hill said that in his experience in talking with his sound experts, that orientation of speakers is one of the best ways to alleviate noise issues. I don't think we get into discussing the size, per se, of this tent that's contemplated. It may be helpful to know that. We didn't discuss, that I can recall, how many speakers are we talking about here? That could be something that, if we thought about and addressed, we could get feedback. It may help us to sort through the sound issue.
We did we did say we'd limit the size of it to 200 people, which also suggests an approximate size of the tent. I mean,
Right. But we could perhaps think about a condition related to the number of speakers. I mean, we've been stuck in events, all of us, I think, where we've been trapped in a room and it's just incredibly loud and we're not having a good time. As to the 200-foot setback off Chestnut, in walking the property, in hearing the testimony, I don't think that is something, just in my view here, that is necessary. I just don't see it as being necessary for the applicant to limit guests to within 200 foot of Chestnut, especially as we've discussed. Historic New England owns the land beyond Chestnut, and I just think it's a significant area of buffer that would address any of these issues. As to the term, I agree with Jeffrey. I think 2 years is too short of a time. It's not helpful to the function of the museum. I think it would be very detrimental if they had to come back here, especially in light of what they're trying to do with scheduling functions and so forth. I think 5 years obviously with the ability, notice to abutters, the ability to come in and be heard. And that I think leaves us with the issue we were stuck on last time is the frequency of the use, the intensity, the nature, the number. But just in talking about what has been presented, I think that Attorney Hill's description of non-museum related events is a bit too expansive. And we run into that, what was that kite flying festival related or not related? And when he includes 12 per year, 1 per month, to include both indoor and outdoor, I just think it really limits the overall function here of the museum. Somehow we've got to find a middle road, because I think Attorney Lipkin's presentation with respect to no limits on fundraising galas, it sort of just leaves it a bit too open, and I think it raises legitimate concerns with the abutters, so we've got to get somewhere on those issues.
Well, my view of these things are somewhat similar to my colleagues. I look at it a little differently in the sense that I think we should be talking more about the special permit process. We have a lot of experience with special permits in the town of Milton, dealing with much more congested spaces and much more potentially adverse conditions on the neighbors than this particular property presents. And the problem we're facing here is that we have a charitable organization here that has been labeled a gem. Steve O'Donnell from the Milton Historical Society said they have a fabulous reputation. There's no evidence that the 37 or 38 other facilities that this organization owns and successfully operates of any abuses or improper management or failure to take into account neighbors' feelings and neighbors' rights. And so we're looking at these events in a vacuum because the applicant has not started and won't start for another year to operate this particular facility. But we do know that it's a successful organization. They're investing $11 million plus in this particular facility. They have been, in my view, solicitous of the neighbors in trying to reach an accord on very difficult issues because we're dealing in a vacuum. So they have acted in good faith. The neighbors have acted in good faith here. And so I think, as Mr. O'Donnell said, that, and Mr. Jeffrey said, we should act cautiously here. And we shouldn't treat this charitable organization, which is intending to do great things on this property, and to benefit the town, not just in the preservation of open space, but to have a magnificent museum there. We shouldn't put this organization, in my view, on probation. They've done nothing wrong. In fact, they've done everything right from what I see. And they've exhibited goodwill in an attempt to deal with the neighbors. The beauty of the special permit process is that it's always variable. It can change based upon conditions, on performance, on whether there is a nuisance taking place. And we're able to deal with those events on a factual basis and not on a conceptual basis that we're trying to do here now. And that's the problem you face. If you're dealing conceptually, how do you get a definition that's not too restrictive and not too general, but something that allows people to have the flexibility to operate the facility and not think that they're on probation or anything like that, but yet to have cooperation between all of the parties. I look at history here, and you know, the history, it's a different set of circumstances, I'll admit to that, but we have the Milton Marketplace right in East Milton Center, which is a commercial use in a residential zone, an intensely residential zone. Right over the fence, there are backyards of properties. And since they're in a residential zone, anytime they want to make a change to that facility, they come before the Board of Appeals to amend this special permit. It's a wonderful organization. It's wonderful for the town to have that type of upscale marketplace. It's beautifully managed. It's been operating, in my mind, for 15 years or more. We haven't had one complaint, not one complaint from a neighbor on Milton Marketplace. We have Steel and Rye, the new trendy restaurant down in the village. Big parking lot, their hours are somewhat long, a very busy place. It's an exciting place for the town of Milton. It's lively, it's young. They exist by special permits. They've been in operation for 2 or 3 years. We haven't had one complaint. And we have Abbey Park, which is older than Steel and Rye, which is right down in East Milton Square. They operate under a special permit. They have a parking arrangement that is difficult, but they work with it. They work with the neighbors. We haven't had one complaint that Abbey Park has ever violated their special permit. And what I learned from that is that properties and businesses that are well managed by people of goodwill who want to work with the neighbors, they work out their problems and differences. They don't have to come back to the Board of Appeals. Could they? Yes, they could.
Like Eagle Farm.
Well, Eagle Farm is different, and that's and also we have Thayer Nursery. We have a lot of hearings on Thayer Nursery involving the various statutes and special, but I'm not going to go there. I'm suggesting that in my view, and I'm not a seer, I'm not trying to predict the future, but with the track record of this particular organization, and with knowing the good intentions of the neighbors who support this particular use, I think this is going to be a win-win situation for both of them. Maybe there'll be some friction here or there. Maybe some definitions will have to be put into place. But I think that it's such a wonderful benefit from the town. If you read the selectman's letter and you read Mr. O'Donnell's letter, they're a wonderful benefit to the town. And it's maintaining open space up there, and it's putting the open space to a terrific use. I think this is going to be the same situation as the Milton Marketplace. I think you're never going to be back before the board, but you have the opportunity to come back before the board. And so with that in mind, I tend to think that we should proceed slowly, and we should proceed in a manner that is not unduly restrictive, and that is not unduly particular, dealing with the management of a philanthropic property like this one. This Board of Appeals knows nothing about running philanthropic organizations. I don't know how they get financed. I don't know what they need to do. I have no history in it. We'd be the last people you'd want to come before to get a lot of restrictions as to how you should operate your property. You should be telling us, and you have told us how you want to operate the property. So my view is that it's a terrible mistake for this board to get involved in minutiae here and to start to talk about, well, the tent can't be more than 300 feet long, and 50 feet wide, and you can't have more than 3 speakers, and maybe, and you can't have if you have a band, there can only be 4 people, and that's craziness. We can't be getting involved in that type of thing. It doesn't benefit the neighbors. It's going to cause confusion, and it's totally unnecessary. It's micromanaging with unduly specific regulations, a charitable use and a philanthropic organization that has an impeccable reputation. It makes no sense to me unless they don't act reasonably towards their neighbors. And everything I see, they have acted reasonably. And I really think both parties here, Mr. Hill, Mr. Lipkind, you're really very close, except on 2 or 3 issues. So, and since we can deal with those issues here and now, but we can modify them if we deal with them incorrectly, we're in a situation that nobody's going to lose here, because the board, even though this is a quasi-Dover Amendment case, Mr. Hill is absolutely right. If he's running weddings, even though they benefit the charity, I'm not quite sure that gets you under the fence of the Dover Amendment. But on the other hand, I think it's really important that there be this give and take. And I think you have the give and take, and the question is, how do you make your definitions to start out on this process? My view of it in terms of the events, I think it's an impossible task to start to figure out what's museum related, what is mission critical, and this is all psychobabble in my mind. Nobody knows what it means. Maybe the regulators in Washington, D.C. would know what it means. I don't. And I think that's really a slippery slope to go down. It seems to me that the applicant has indicated that it wants museum and historic related uses as its principal activities, but for the weddings. And in my mind, this is a spectacular place to have a wedding. I think that you're going to find a lot of people not only attending the wedding, but touring the mansion as part of the wedding. I know where the photographs of the wedding are going to be taken. They're not going to be taken in the tent. They're going to be taken right up at this beautiful building, and on the inside of the building and in front of the building, and all of the guests will want their photographs taken there too. It's a spectacular location, but the applicant, in my mind, has tried to reasonably suggest that they'll limit the number of weddings to 12. The neighbors agree to 12, and I think that's a wonderful concession. And the question is it one wedding a month, or is it during the summertime, can the applicant have 2 weddings? And I think the problem with the weddings is noise, which is the second part of this. And if the noise is too much, then certainly the neighbors need to be protected. So I don't think at the initial stages of this that I would insist that there be 1 wedding a month. And I would certainly give the applicant the benefit of the doubt and the benefit of operating the property, as long as it's operating the property in a way that is not offensive to the neighbors. So if there were 2 quiet weddings a month, and it fosters this charitable use, I would tend to allow that. I think I disagree with Mr. Mullen adopting the DEP regulations as part of the board's decision. I don't think that's really good at all, because then you have the Board of Appeals involved with these regulations, which frankly I don't understand. It's like traffic engineering. But that doesn't mean that if the neighbors believe that the noise emanating from a wedding is too loud or unreasonably loud or noisy, or whatever the expression that Attorney Lipkind uses, that they can't do their own testing to try to determine precisely and in a scientific way what the decibel level is, and you could mention that. You could come to the board. You could go to the building inspector. My guess is that there'll be policemen present at these weddings, at least in the initial stages. It certainly would be a good idea. And, you know, I think that's the way most weddings are set. So I don't think it's prudent for the Board of Appeals to adopt the DEP regulations as part of this. But certainly we can take judicial notice of them or administrative notice of them in the 10 decibel standards. I don't think we have to adopt it as part of the decision to do that. And I think with respect to the orientation of the speakers, Mr. Attorney Hill says that that's critical. The applicant says, well, we're going to aim the speakers towards the gatehouse. Well, I don't know whether that's going to work or not, but my suggestion is give them a shot at doing that. I frankly don't understand why it couldn't be, the speakers couldn't be directed away from the gatehouse and towards the west. But you know, that's something that can be worked out on trial and error basis. I can't imagine that if the neighbors were complaining that the orientation of the speakers was causing them discomfort or not allowing them to peaceably enjoy their residences, I can't imagine that the people running these events wouldn't turn the speakers and see if that cured the issue. I do think that a 2-year look-back term is inappropriate. I understand why Mr. Hill makes that argument. It's an argument that he's making for the benefits of his client, but I think practically it is too short, and I actually think that the 5-year term that Mr. Mullen and Mr. Lundbohm suggested is reasonable. And what Mr. Lipkind has done in his proposal is he has adopted the standard of renewal as set forth in the Hop Garden case. It seems to me like this is a very sensible way to go because it allows, even though it's 5 years, it to be automatically renewed, but there's a newspaper publication, and if somebody objects to it, then there's a public hearing, and you can introduce evidence on any of these issues. It's a way that if there are no issues and no violations of the conditions that we establish, you're not requiring the applicant to come before the Board of Appeals. So what are you coming before us for if there's nobody objecting to it? So I think the condition set forth in Mr. Lipkin's proposal, which is the actual condition that the appeals court, in a rescript opinion, affirmed, I think is the reasonable way to go. So my view of we should adopt reasonable conditions here that aren't unduly restrictive, that don't contain definitions that we can't understand. Let the process work, and I think that if certain aspects of this need to be tweaked, we can easily do it under the special permit provisions protecting all the neighbors, so that that basically. And I also think that I know Mr. Lipkin didn't seem to agree with me, but I really think that restricting the weddings to premier memberships of the HNE is really it's a beneficial condition for the neighbors, because I think you have much more control over those people. You're not dealing with unknown personalities. You can get a better idea as to the type of wedding that's going to be conducted, and making sure that the wedding is an appropriate type of wedding that fits in with the Eustis estate and the neighborhood, and not somebody who's going to do a reggae wedding, some crazy wedding that's going to disturb everybody. So I think there are enough checks and balances here to come to a sensible solution. So that's, in a long-winded way, those are my thoughts. I think we can make reasonable conditions here, keep them on the general side. And in my estimation here, I do not see a reasonable likelihood that there's going to be a lot of contested issues dealing with those conditions. Mr. Mullen, do you have anything to say?
I want to talk about the weddings, but I don't want to talk about it right now. I want to talk about a couple other things. I wasn't suggesting that we adopt the DEP regs into the permit. We don't know anything about that. I think the regs apply because they only apply if it's a parade, a public gathering, or a sporting event for which a permit has been issued. It's not a public gathering. There's been no suggestion that there is a public gatherings. And my point is, I'd like to stipulate that that's the standard of noise that we're trying to meet, rather than have something be reasonable or unreasonable. And since the Commonwealth has said it.
Well, then you're requiring people to go out and do
No.
scientific testing at tremendous
No,
expense.
you're just saying, look, we have a noise ordinance, we have a noise bylaw, we have a noise.
How can you determine it if you don't have engineers, the fancy engineers, charging all kinds of money to determine what the decibel level is?
I wouldn't be concerned if the applicant came and said, you know what, we're subject to this, just like everybody else. Then you are. But there's been testimony here that suggests that they're not subject to it. I don't agree with that. I think they are subject to it. I think all private functions are subject to the DEP noise guideline. And I have no idea why you wouldn't be, you know? So I understand there may be a permit issued for the wedding or for the activity, but that's not the kind of thing that's accepted in this. These are public gatherings. They're really concerts and games and parades and things like that. So what I'm thinking about, it's not a big issue, I don't think, because ultimately this will probably be the standard should this be an issue, is trying to define what's reasonable and what's unreasonable. And it seems to me that this already does it for us.
Well, it may, and if it's, you can certainly notice that, you certainly can reference it, but I just want to be careful that somebody who has a noise complaint doesn't think they have to go out and hire some fancy testing firm in order to prove their case.
No. So let me put it another way. Another way to address this is you could state that there'd be a restriction on unreasonable noise, and that what's deemed to be unreasonable is in the regulation. You could do something like that.
You could. I just don't know whether the regulations are applicable to weddings. I have no expertise in this area.
And how do you know what's reasonable and what's unreasonable?
I think what's reasonable and unreasonable depends on what Mr. Shillingford tells us he can hear from his house, what the police officer has to say who's right there, what other neighbors have to say. And I assume if there were a lot of complaints, they're going to turn down the noise.
Yeah.
I would think the police officer would tell, can't you calm this down a little without taking out a decimal meter, a decibel meter to test what the noise is? I don't know.
Okay, let's talk about a couple other things. We didn't talk about no use of Chestnut Run. I know there was testimony to it, but to the extent that there are conditions on it, I think we should.
Well, I think that's basically agreed to, and I think the only thing that Mr. Lipkin mentioned is that some of the staff that takes care of the grounds may have to use that, and that's certainly fine, because apparently is it the Brookwood or Brookdale Farm up there uses this particular road to have their tractors.
So
and other
with the
things
staff
up.
exception, on the use of the
I'm sorry. Who do you need?
on the use of the parking, they're asking for approval on the numbers, 13 behind the carriage house and 48 in the rear.
Correct. Plus over.
I don't think there's any disagreement on those numbers. to the
We
best
just
of my
haven't talked
knowledge.
about it, so I want to get that on the record.
Yep.
And that the parking lots will be constructed in accordance with the requirements of the bylaw, because the bylaw gets into details on how parking can be built. You're aware of that?
Yes,
Bob?
I am, sir.
Yeah. So that was in the building inspector's letter. We didn't really talk about that, but I think we should note that for the record. And the same with respect to the removal of the crushed stone, which, given the size of the property, is small. I think the bylaw is really intended for small lots, but I want to make a comment on that. And that the uses as determined, as approved, or as in the special permit would be as set forth in this drawing, because there are some important differences here, or modifications, including that new curb cut on Canton Ave.
Correct.
Scenic byway, so that the visitors will be coming through the new curb cut rather than through the gatehouse.
Correct.
Except for, to get to those 13 parking spaces behind the gatehouse. Yeah, okay. On the term, I think the, I had said earlier the 5, I think that's great. But
By the way, can I just say one thing, Jeffrey?
Yeah.
Because just so that the people out there understand, even though there's a 5-year term, if the
Yeah.
conditions are violated on the second day
Yeah.
of this special permit, you've got the right to go to the building inspector, to go to the police department, to file a complaint with the Board of Appeals. And I'm sure Mr. Hill is not bashful about doing so. So you really don't have to wait 2 years or 5 years to do it. This is an ongoing, active process, and if you feel that the conditions aren't being met, obviously the most reasonable thing would be to talk to Mr. Sheffield, talk to Attorney Lipkin, talk to Joe Prondak, and bring your grievances to him, and hopefully it would all be worked out. But if it can't be worked out for whatever reason, you've got the absolute right to file a petition for enforcement of those regulations and conditions with the Board of Appeals. So you don't have to wait a year, 2 years, 6 months, or 2 weeks. I'm sorry, Jeffrey, go ahead.
I agree. That's the way it would be. If we're going to draw the distinction between weddings and everything else, that's terrific, but that's not what I heard.
From whom?
I didn't hear that from anybody. I heard.
Mr. Lipkin's suggestion was that it's an event where you have amplification of sound.
Right.
That's the trigger mechanism.
Right. And sometimes those are weddings.
And then they say, well, weddings, maybe weddings don't fit within the Dover Amendment exceptions and all of this, but we understand that the charity needs to fund the operation, so we'll agree to 12 weddings, but then they say 1 wedding a month. So, I mean, that's a stipulation that we have here. And the only question is, how many weddings? Do we have 1 wedding a month, or do we allow up to 2 weddings a month with amplification? And we're saying if it's indoors,
Really?
then it's related to the museum. They're not going to have bingo sessions indoors here. It has to be somehow related to the use.
Okay.
But if you want to define it, it's impossible to define.
I don't want to get specific. I like general, but I just thought we were talking about more than weddings. Is it only weddings?
It's principally weddings, is it not?
Yeah, it would be.
That may be
I can't
outside
see
of the
another-
realm of.
Important, right? It's either.
I can't see another reason for having a non-museum sound amplification.
Well, no, this is the whole case, right?
Can I ask a question?
Yeah.
Sure.
I don't want to be out of order, but if they're going to say, we're only going to do weddings, then the permit should say that. But if they might have a party that's not a wedding, then it really shouldn't just be weddings. It should be any of them.
Right, I think the problem being weddings are somewhat unique in terms of the size and the merriment and the, so, I mean, but I think we should specifically deal with weddings because that's something that may not be within the penumbra of what's a.
My guess is that, for the most part, it would be a wedding, and Ms. Vieira can correct me, but I understand Mr. Hill's point. What if someone had a 50th anniversary party? It's not a wedding, but it's a functional equivalent? Yeah,
Right, your proposed conditions don't limit it to weddings.
Right.
You
I-
Well,
suggest
say
that,
any
I was
event
trying-
that's amplified, is
I
that
was
what you're
trying-
suggesting?
Right, I thought that's what the concern was, and that's why I went that
An
way.
outdoor amplification.
Okay. Does that help, Jeffrey?
Well, that's what I thought I heard, right.
Okay, well-
But does it go against the 12? I mean, I think it has to, and it's not just weddings.
Well, it's up to 12 events that have amplification.
Right.
Cut weddings out and put events.
Regardless of whether they're related to the museum or not.
Right.
Well, the weddings aren't technically related to the museum.
No, I
or not.
understand, but you could have an event related to the museum that says amplification. Could be outdoors,
Yes.
and that would go against the 12.
That would be a
Would go against
right
the
line approach.
The only exclusion I had suggested for that in my proposed conditions was for the gala-type event, which Ms. Vieira said at the last hearing happened once a year, maybe. I thought
Yeah.
she said something like that.
I don't feel like, well, I don't know.
Yeah.
I'm happy to talk to,
But it's not a large number, but it is an essential museum function.
We can live with that, within that number if they give us 12
Yep.
months.
okay.
You still have the.
Well, that
full-
kind of makes it 13, right?
It does.
I mean, so I don't like that. I just, that doesn't,
We'd keep it within the 12.
Okay.
Okay.
go ahead, we need to talk a little bit more about this, but
Well, it's almost 10 o'clock, so let's see if we can talk and move on before we fall asleep. I don't want to bring everyone back here for another hearing to discuss these conditions.
So we talked about the other conditions to be issued on the special permit, and we've talked about each of the 4 matters for which relief has been asked for the board.
Yep.
And we've conditioned this potential special permit in a number of ways. There are at least 6 terms that I wrote down. But just to be clear, what we're hearing and what the board is talking about is permitting the use of the museum for up to 12 outdoor sound amplified events per year, 1 per month.
Including galas.
Yes, but 2 per
2
month.
per month.
Up to 2 per month.
And that would include galas.
Okay.
You don't have to say that, right? It includes everything.
That's right.
No, I know. I don't want to include gala. I want, it's everything. Every event.
Everything. Includes everything.
Gala, wedding,
Even funerals.
Bruno, Baron, the Baron Hugo, you know, Bob, all the
Yes.
events you go to.
Yep.
So,
I'd object to that if I were you, Mr. Sheffield.
Baron Hugo
Because you
events.
shouldn't be
He was
critical of
playing
Mr.
at the totem
Sheffield
pole on
because
my
he
first
enjoys
date.
good music.
Mr. Leonard, he was playing at the totem pole on my first date with my wife.
Good for you.
I'll hear from the other members. I've talked enough.
Mr. Lundbaum.
I always like to defer to the wealth and breadth of experience and knowledge of the chairman. And I take a lot of his comments to heart here. I think we do need to defer to the reputation and experience of the applicant when we're trying to define these things. And I think, in my mind, I am close to where I want to be with regard to the conditions. And as the chairman said, if a problem arises, there's always the ability to seek a hearing, to seek enforcement, and I don't think we need to get caught up in, as the chairman said, the minutia here. Don't define these outdoor events in particular, and I think the 12 and 2 works, and I think that I think everybody knows that we're going to be dealing within probably a 5 to 6 month window or less when we're dealing with these events, and I think the applicant would live up to the spirit of the agreement with respect to noise, but we have to take a shot here put some conditions together and see what happens. I don't know what more we can do.
Mr. Mullen, it's your turn again. Do you want to be heard?
No, I'm interested in what you think.
Well, I think we've basically come to consensus. I think that doing the 12 events without definition is, as long as it's with sound amplification, I think is a condition that's easily enforced.
What is the condition?
The condition is that the applicant can have 12 outdoor sound amplified events per year, so long as the noise caused by the amplification is either unreasonable, so as to constitute a nuisance, or, as you've suggested, violates the DEP regulations.
Is that what it's going to say?
Yes,
Is that what you said?
something to that effect.
With the
yes.
either or in it?
Well, yes. So how else could you categorize it?
No, I think that would be good. I mean, I think that, I would like
It
that.
certainly is. The DEP regulation could be evidence of unreasonable noise, but I don't think we should say that's the test we're going to apply. I think the test should be a more general test, and I think. I think it's going. I think it's going to end up with a policeman at the wedding saying, "Hey, calm down, guys. This is making too much noise," and not going out with
Don't
testing
talk about
devices.
weddings. It gets confusing.
The
Weddings
events.
are emotional. You should pay for some weddings, and you'll
I have
understand
3
it.
boys. The,
You have to admit, this is a spectacular
Plan it that
location to have a social event.
Yeah, yeah. So with all the conditions we've previously stated, you've got 12 outdoor sound amplified events per year,
Yes,
2 per month,
yes,
on the condition that they not provide unreasonable noise, provide noise that is either unreasonable or
or violate.
or
violate,
violative of the DEP standard in 310 CMR. No.
Well, why don't we just say violative of other applicable sound regulations? I don't know whether that's applicable. You think it is. If you show me some authority, I'll.
It's only not applicable for parades, public gatherings, and sporting events.
So it's applicable for parties at my house.
Oh, yeah, absolutely.
The DEP is regulating
The town relies on that.
how loud I can
That's when
play
the
the
policeman
radio at my
comes, he
house.
points to the regulation to which Bob referred.
Okay. Then what does he do? Take out a...
I don't know, I haven't been to your
a
house.
little, does he take out a testing device and... You'd
I'd
need,
like to go
you'd need a,
sometime,
you'd need a
actually.
sound...
That raises
I'm
another
going
issue.
to buy Bob
long have
Quinn's
we known
house.
each
That's what
other?
and I'll be subject to the noise. But no, seriously, what you need an engineering firm. You'd need the testing and a sound engineering firm in order to apply that standard. Nobody's going to do that unless the neighbors think that they're not getting the satisfaction they deserve, and they want to quantify what they believe is the unreasonable noise.
All right. I think it's fine if you said that the noise must be, it can't be unreasonable.
Yep.
And if we have reference in the decision to a discussion about that will be an issue, that could be an issue about what we talked about, whether or not that applied or didn't apply. We should just take notice that there was a discussion about the DEP noise regulation in the decision.
Right.
Fair enough?
That's fine. Fair enough.
Sounds good.
Steve?
Yeah, no, that's fair.
Steve's on board.
And yeah, I don't have any further.
Yeah, then you deal with these issues on a case-by-case basis, and we're not making decisions and drafting such technical conditions that we have no application of fact. The applicant has no track record, except one of cooperation and hopefully great success. Mr. Hill, did you want to say something?
If I may,
Is that-
He's acting like.
I see.
Sorry, bad habit. I think I see where you're heading, and I think in light of that, I'd like to just make a couple small requests. First, that the neighbors be given some reasonable notice in advance of events. So I don't know quite how to.
Such
frame
as a
this.
posting on their website or something? Do you do that? Do you post?
I don't know what events he means. It means the 12 events?
Yeah,
Yeah.
yes.
The weddings, the special events.
Outdoor amplified events.
Exactly.
Yes.
So maybe there could be some communication to a designated person in the neighborhood.
Let's-
Okay with that.
7 days in advance, something reasonable, so that we know in advance, when these are gonna happen. If people wanna get away for the weekend or something like that, they have that option.
You have a website? Is this facility going to have a website?
Yes, it will be on our website. We wouldn't put someone's rented for special events on our website, but we could certainly communicate with the neighbors.
Yeah, presumably these are gonna be scheduled.
It's safer if you put it on your website, if you just said wedding Tuesday afternoon from 2 to 5 or something. But
It sounds like they're gonna be scheduled pretty far in advance, so maybe
Well, I
they
think- I
could,
think
you could
that's
just send
right.
us an email with the schedule for the summer, and then we'd know when the dates are.
They
Yes.
have our emails.
We can do that.
Okay.
They should give us a contact person who they'd like us to notify.
I think Mr. Lipkin's right. Why don't you provide, at the appropriate time, a contact person with an email address so they can be contacted?
Sure.
Okay.
But can we just put that in the decision?
Yes.
Condition that the neighbors would be given reasonable notice?
You gotta do them both. You gotta
7
put
days.
both in.
Yes.
You gotta do both. You've gotta say that the neighbors will provide a contact person, and that contact
Oh, yeah,
person will
sure,
be
absolutely.
notified. Yeah,
Yes.
so it's gotta work both
That's
ways.
fine.
And what's the time frame?
Just put me in there as the initial contact.
No,
and we'll
don't
just
put a lawyer
substitute-
in. Don't put a
for us.
lawyer in.
No, we'll just substitute somebody else in, and we'll
Okay.
figure out who it is. And
That's fine. 14 days? Yeah, I mean, what's raised, is that fine? 14 days in advance, how's that?
Great.
Okay, fine.
So that's the first. Second, it'd be helpful if,
Well, let me ask you, on this thought, I know that I'm just probably violating a rule here. Is it a good idea to have the neighbors have a point of contact for each other? Is that a good idea or a bad idea? Does that help or hurt? In other words, they're going to be more than just, issues, right? They're going to be more than just notices. Should it say that the neighbors will provide the name of a person with whom the applicant can deal, or is that?
How's that enforceable?
Yeah,
Because
okay.
we don't have an organization, the neighbors
All
are
right.
not organized.
I know.
That's why
I
I
know.
thought posting something
Yeah.
on the website of the charity would be notice to everybody.
We'll leave it at the point where you'll provide neighbors will provide a contact person and notice of special events, the types of events about which we spoke will be provided not earlier than 14 days in advance.
and we'll
Fair
worry
enough.
about our communication.
That's
Great.
fine.
Okay,
Okay.
terrific.
That's our
Does
problem.
that work for you?
Not later than.
Not later. Yeah, okay, sorry. Yeah, that's right.
And Mr. Hill, you had another issue.
Number two, can we have the applicant submit a revised plan that actually shows the location of the tent stage area? Because I'm just concerned, Mr. Chairman, that
Well,
what they've shown, what they're describing today may not necessarily be what happens 3 months from now. They might move the stage.
No, that's going to be, that's why I
That's
referred
why
to
he's got
that.
it for the record.
That doesn't show
But it doesn't show the tent.
Not on there, though.
location, and I think that falls under the framework of micromanaging. The tents aren't always going to be the same size, and it's kind of like speaker location. We'll see what works out. There's not that many places that are flat on that property and close to the bathrooms that are going to be in the Welcome Center. So we know in general where it's going to be. There's a little loop road just near that, near the Welcome Center, and it's got to be there because that's where the bathrooms are going to be.
Well, I think, Mr. Chairman, just in my defense, I think this is the real critical issue is what is the sound source? The sound source is going to be amplification. That's the condition, the prerequisite that Mr. Lipkin had asked the board to adopt. So I think it's not unreasonable for us to ask, where is that sound amplification going to be in the property?
And I sketched it out for you where it's going to be in general, but we didn't have it put in. It's not going to be on a fixed pad. The size of the tent's going to vary somewhat. And I told you in general what the orientation's going to be, and that's where we think it's going to be. I mean, I could show you that sketch again if that's.
No, I
of any
have the
comfort to
sketch
you.
in mind. In fact, I marked my plan to show your location.
Okay.
Why can't we say that?
Well, we can, but it's a question of what if they wanted to move the tent 50 feet in one direction?
Well, it's going to be generally to the,
But, you know, what if we move
wanna-
it further away from all their houses and it has no impact on them? I think they're so protected by the noise standard.
How about saying no,
Forget it.
no closer than the rear portion of the,
what's the west side?
yeah, is that the west side? Okay, how about saying it's to be no closer than the furthest edge of the west side of the building?
Yeah,
And just keep it
That's
that way.
fine.
So in other words, it's not going to be to the rear of the building, and it's not going to be, it's got to
I
be,
have no idea what that condition is.
that's all right.
What is that proposed condition?
well,
I'm sorry.
it's to draw a line
Back up there?
on the back of the building here and say it won't be any closer to the neighbor's properties than this line in here, just right there.
Yeah,
You can go
It won't
anywhere,
be
we'll
any
put it
closer
anywhere.
To these neighbors?
Yes.
why don't we say it won't be any closer to Chestnut Run, rather than have neighbors all over the
Well,
place.
you do.
All around.
I think Mr. Sheffield is right.
And is the west side the side closest to Chestnut Run?
That's what Mr. Mullins says.
The building,
Office Road.
yeah, it does here. The building kind of, north is kind of like that.
So west is that one.
No, that's east.
Oh,
yeah, north
then-
is
then
that way.
we
That's
we
east.
want to say east, don't we?
That would be west.
West.
Well, do you want
Well, the
front
tent
or rear
is
of the
here.
building? What's that?
Yeah, the tent is going to be right there.
No, I thought the tent was supposed to be in here.
That's where we put it. Right?
I don't think so. This where I drew the tent.
Oh, funny.
Yeah, no, he didn't put it there, John. He put it,
Back here.
Oh, then I may have it reversed.
he put it here. Right.
So you're actually over here. Jeffrey, you're correct. So the somewhere over in that area. Okay, so you're saying it won't be,
This has an arrow on it.
Yeah,
yes.
yeah,
It's kind of like, you know what you could say?
he said here.
You know what you could say is it just the
John
tent
thought he
won't
was
be any
over here.
closer to
He was
Chestnut's
over
Run than the museum.
So it's to the south
Say
and the
that.
west, yeah.
Looks like south.
They'd be putting it over the roadway.
Right, okay.
That's
You want to
fine.
do that?
Yeah, because the overflow park is here,
Yeah.
so it can't be anywhere but right here.
Okay, that's
Okay,
fine.
that's a good idea, Bob. It would be, this here?
No, it's this, right there.
This is like southwest.
But
This is northeast.
all we want to do is draw a line and say it won't be closer than, it will not intrude back there.
I guess I just don't understand the concern, because you're going to be running into paved area to go over there. and I'm
I
very
think
confused
he's
about the
thinking he
direction.
doesn't want the tent there.
From here?
Yeah. Right?
I think the concept is that there'd be a line here, so
I should
nothing
ask
this
my
way.
son, who writes for Rolling Stone, about how loud is loud.
That's right, that's right.
I think if you said something like the tent would be proximate to the museum, but will not be located any closer to Chestnut's Run than the museum is, I think that covers it, without getting into a direction problem.
That would be fine.
Does it matter?
Yeah. But it is, it's over the museum. He doesn't care, but you're going to be barring that.
Oh, then the closest point to Chestnut's Run.
Yes.
Closest point of the
Yeah,
museum.
yeah.
Yeah.
Okay.
I'm sorry, I didn't understand that. That works.
I think that works.
Yeah, no, that works. I didn't understand what you were saying. But I get that.
That works.
Okay. You have anything else? Mr. Hill, Mr. Sheffield, did you have
Yes,
something to say?
I was wondering if you would approve the removal of up to 1,000 cubic yards of fill from the site?
Yeah, that's condition number 4.
Yes, I know you've talked about the bringing into the property the crushed stone. And I think in the discussion, you should take also take recognition of the removal of up to 1,000. I
think I did.
Okay. Okay. Mr. Hill, you all set?
Yes.
Okay. Jeffrey? Stephen?
All set.
Okay, let me do this. Let me thank everybody for their patience and their tolerance and sticking with this. I think this is going to work, and if it doesn't work, we'll deal with it appropriately. So thank you for coming tonight. Thank you for your hard work and your attention. It's an important issue to the neighbors. It's important to the charity here, and it's certainly very important to the town. I think this is going to be a wonderful solution for everybody. So thank you very much for coming. Have a good night, and we're adjourned.
Thank you. I want to